I know.
Hey, how's it going?
I don't know if you got my email. I was trying to see first draft of the letter.
Do you guys have a good dinner?
Yeah, we were in, got some.
Yeah.
Okay.
So that as you go through his invasion,
Keeping your head above water.
my card.
Yeah, unfortunately, Alan, Dr. Combs couldn't swim today, so.
Yeah.
I talked to Juan about this.
I know a lot of people actually.
Oh, testing, 1, 2, 3.
We actually had parts run out
Still that was doing your own.
Yeah, well, thanks for
The business said we can't, here's what we have to do. I don't think this is coming out. Now, they're adding that? So you don't have to notice. It doesn't matter. Right now it doesn't. Doesn't have to notice anyway. She'll be right back. Why don't you take her?
I don't have anybody else here unless she.
No, she don't have to get her glasses.
Is there a packet?
So that was the meetings from the last meeting. Minutes. Thank you. Sorry, you might add a brief.
That's big, and they need her like instantly, so her last day is next week.
We never even met her.
I know. She had planned on being, so there's a lot, public health has been going, I know I stated before, we're going through a lot of restructure, because of the specific House bill that, says that management, it's an 11-to-1 ratio from manager to supervise. So we went through that restructure, as you guys know, and now we're centers.
Actually, can we, are we ready to officially start the meeting? So-
Yeah.
Okay, wait, if you get your report.
Good,
just a
I just
second,
wanted to
so-
say something while we're waiting, so that's good.
Sure, appreciate it. All right. Okay, welcome to the Advisory Committee meeting, regular quarterly meeting here in Portland. I guess we'll start with introductions, starting with Stormy and going around the horn.
Hi, I'm Stormy Ray from Eastern Oregon, and I'm glad to be here. I'm glad to see you guys here to support this great program.
Cheryl Smith, I'm the Director of Compassion Center in Eugene.
Jim Clark from Brisbane, right at this moment. Patient advocate.
Todd Delato, Chair of the ACMM, Chair of the Horticulture Research and Safety Committee, and I also am President of CAN Research, Education and Consulting in Corvallis.
Alice Eisenman, patient advocate.
Sandy Burbank, I'm the executive director of Mothers Against Misuse and Abuse. We have clinics in 3 locations, and I'm a patient and a grower.
My name is Ben Mackinus, and I am a patient and a grower, and I live in Columbia.
Carroll, law enforcement liaison for the OMMP.
Tawana Nichols, the section manager for the medical marijuana program.
Aaron Cossell, I'm the custodian of records for the Oregon Medical Marijuana Program.
And if you like, we can go around introducing the audience.
PK for Mercy TV, channel 23. Mercy.
Don Morse, Human Collective.
Courtney Moran, an attorney.
David Aiken, citizen.
Brenda Thomas, Happy Cannabis Foundation advocate.
Lori Duckworth, Southern Oregon Normal at the Cannabis Community Center.
Your turn, Santa.
Santa. If I'm the North Pole. No, from Skipper's.
Harry.
Perry, Stripling, Mercy News, and Points Beyond.
And I'm Pamela Tyler Crum. I work for MAMA, for Mothers Against Misuse and Abuse.
Great. I guess we could look at the meeting minutes. Tawana or Aaron, do you know if John had incorporated the changes to the minutes that we went by email?
I believe he did. He didn't indicate that he didn't, and he did mention the minutes to me this morning.
Okay.
I didn't say that he did.
Does anyone have any changes to the September 12th, 2012 meeting minutes?
Todd, would you look at them real quick in areas that you know that just see if any of those changes that you know to make sure.
I wish I could remember some.
Yeah, unless you just sent them out a day or two ago.
He usually does it
Should
immediately.
get those at the beginning of the show, so remember.
Okay. All right, so anybody want to make a motion to pass minutes?
I'll make a motion. I'll second that.
Okay, and just friendly amendment passing, but assuming that the changes were made via email previous. Okay, all in favor of passing the minutes?
Aye.
Motion passed unanimously. All right, and now over to the program. Thank you for coming in. Actually, may I make a motion to pass the meeting minutes for 9/12/12 as we did before, except for on page 2, change Ms. Delato to Mr. Delato. That would be so much appreciated.
Please. See, that was one area you could have recognized it anyway.
Okay. Somebody please second that.
Sorry.
Okay, all in favor?
Aye.
Okay, motion passed, thank you. All right, and on to program.
Okay, I apologize, I'm not doing well.
And also, the chair notes, Brian Michaels just is in attendance, and Laird Funk and Dr. Ellen Cohen are excused absences.
And we're hoping to.
Oh,
Okay,
okay.
and now on to Tawana, thank you.
What about the other doctor?
He hasn't called in. Dr. Cohen's excused, Dr. Laird hasn't made contact.
So, personnel update, we currently have 27 permanent employees and 1 temp employee. We lost Annette in August. Then we had someone that was removed from service, and another person was on medical leave and decided not to come back. So I had a couple surprises. So they are in the process of being recruited for. I'm recruiting for 4 positions. That doesn't include the office manager position. We're looking at restructuring the program. because there's a total of 20, the positions FTE for the program is 31 FTE. And me as one manager, it doesn't, it's hard for a person, one manager to manage 30 employees. And so even if I had a second office manager, that doesn't look like what I need at this point because the program's grown so large. So we're looking at restructuring, as far as looking at getting me possibly an assistant and possibly hiring 2 other managers to help support me in managing that large amount of staff. And plus, there was a House bill that went in effect back in July that says that supervisor to employees should be 11-to-1, and I have 30-to-1. So we're looking at that's why the recruitment hasn't been submitted for the office manager. So I've been a busy person lately, trying to look at how to improve OMMP so that we can provide the service. Aaron, you want to give us statistics?
Yep. All right, so as of this morning, we're at 57,634 medical marijuana patients.
Could you repeat that, 57?
57,634.
Thank you.
The number of unique caregivers, meaning we don't count the same person twice, is 28,865, and growers is 40,600. Wow. The number of registrations we've received where the patients list themselves as a grower is 28,736, and the number where they list a different person as a grower is 31,116. And we currently have approximately 1,587 physicians with a current patient on the medical marijuana program. And then some of the out-of-state participants, we have these would be people who listed a mailing address out of the state of Oregon. There are 875 patients, 338 caregivers, and 361 growers. And just as a reminder, the grow site has to be in the state, but you can list an out-of-state address.
Is there a printout for that, like we got in the past?
It's not in your folders?
No, all I got in the whole folder with meeting minutes.
Yeah, you know what, I'll get those at the break. I'll get copies.
I thought John was putting it together.
Yeah.
Also, I was saying before we got started that Gail has accepted a position, what's it again?
As the chief of staff for the mayor, Charlie Hales in Portland.
And she will be, her last day with us will be the 15th of December. And right now, I don't know who the interim administrator would be. We met yesterday to discuss how things are gonna transition as she moves on. And at that time, they don't have an interim. And as soon as I know who the interim will be, I'll share that information with you. The budget, we don't have it, but I'll try to get that, I'll have Aaron get it at the break also. We thought the packet was put together, and I apologize again for not having it present. But our current cash balance is 3.2 million. And the revenue for the total biennium is a little over 10 million. And so far, to support the other programs for the biennium, we so far put out, that's just as much as our cash. 3.4 million to the other programs we support have been transferred out. I'll have a budget where you can see it.
Okay, yeah.
I'll bring it because I see your questions when you were to see what that looks like and to see the other line items. But I will look at that at the break. I'll have Aaron bring it back down.
Are you done with the budget?
Yes, the budget.
I was kind of expecting, because at the last 2 meetings, we made a motion to start the process of figuring out what we could lower
Yes.
the fees to.
And I've sent that information to both Jeff and Gail, and I didn't get a response yet. And I sent it twice. I sent it, the beginning after the meeting as a follow-up, and then I sent it to her last week or 2 weeks ago. It may have been last week, because she had asked what think topics, and I sent her that information again, her and Jeff.
So a half a year has passed since we originally asked for this information, another 3 months since we voted on it again last
Right.
time. If our motions are not going to be acted on, I just am having a really hard time justifying the time and energy that I spend coming to these meetings if it doesn't mean anything. And the fact that we keep getting, I haven't even met well, I guess, who was the guy, Barry? We met Barry, sorta.
Yeah, Barry was interim, so he was only here for.
We never met Gail. Was there somebody, I'm so confused, I didn't even know who was supposed to be.
I understand, think of how I feel having 5 bosses and then
You
telling
guys,
me how to do
you
my
know we
program.
love you, you know
Yeah.
we love you, and you're obviously
I can
working
expect-
under
I can see.
extreme conditions, but
Right.
what I have
I
to
can
ask
Mhm.
is maybe we need to send a letter as a committee to these people, including Dr., the one who appointed us.
Goldberg.
Yeah,
Uh-huh.
and say, are we just wasting our time and money here? Because it sure seems like it. I would like to make, oh, go ahead, yeah, let's talk this over before any motions,
Oh, yeah, I mean,
if you don't.
so, yeah, because I was reviewing it too, and I was looking at, out of 60 motions, like we brought last time, made since July of this year, or June of this year, last time. Out of 60 motions made by the ACM since its inception 7 years ago, only 9 of the 60 motions passed.
How many motions?
9 of the 60 motions passed were implemented.
60 motions.
60 motions. There's 3 that are still unresolved, we don't have an answer to. And there's been more that have been added on to this in the last meeting, but I haven't added these to the numbers. But since 2010, which is extra disconcerting, so 9 for the full 7 years. Since 2010, not a single motion that we've passed has been implemented, which coincidentally looks a lot like tying in with when Major 74 and all this happened. Could be a coincidence, but they're just a striking number of them. The second is now it seems from the changes that are implementing on some of these for public meetings and different things that we're seeing, it seems like magically the special meetings going away and all that, the emergency meetings sort of, because once again, we won't really have any say on it. We're gonna give our opinions and then nothing probably will happen looking at history, right? But now this most recent action is something, in my opinion, much more concerning to me, is that it looks like active punitive damages. We hold an emergency meeting, we request to get reimbursed for that, and then they say, well, actually, it's a little gray, so we're gonna rewrite your entire system, rewrite everything. Not that it really matters anyways, because it was ignored when we specifically, when the legislator passed it, we were never consulted, as is our mission, right? And when you start compounding these, what we've led is we're already a toothless organization. And by the new stuff, now we're taking away our gums too. And when you start looking at a certain point, I mirror the question, why be here if all this works? All we can do is basically document atrocities, right? Even the UN has more teeth than we do. You know what I mean? Like there's no, and I know once again, I know this isn't directed, please don't hear it as an anger review. It's just it's a frustration that I really came on for wanting to make a difference for people. And I don't have 30 years of experience like everyone else, but I sure, and I'll stop talking. I'm just really exceedingly frustrated at what do we do? Because basically, why are we here if not a single bit of advice is taken and we're just blatantly ignored from all our requests? And once again, I understand it's not your intentionality, but it's by design, right? This is all by design, by someone. And I guess my question for you is, obviously, someone's instructing to have all these things done on a management level above you, correct? You know, in some ways, legislatively, right?
Right.
Are we privy to know that, and how can we make a difference? That's just my direct question. How can we make a difference? Because right now, we obviously, by facts, are not. So that's, I guess, my question to you. And then, if I know you can't answer it, who can?
Okay, I can answer, and I hear your frustration. I do my part, is this is what's asked, I take it to them. I said, like I said it to him twice. I said, Jeff, I need an answer, because what's happening? He doesn't have an answer, but I'm sure somebody above him has an answer. And I have to keep on, I'm trying to get the information, but yes, you guys' role is advised, and it's the director, Dr. Goldberg, that should be responding. I send it to the channels, I wait for an answer, and as far as bylaws, that was to clean up some of the things that hasn't been addressed. And also, there's things up underneath, there's other rules and policies that we had, like when you sat on the Rules Advisory Committee, there's policy and rules of how people get paid for those services, and there's things in there that says that in the county that says that you're not reimbursed for the Rules Advisory Committee. So that's where they're looking at to address this as well. And what drives us is the statute and the rules. And so the bylaws need to be cleaned up, some things to address the one about the language around.
Well, actually, I didn't mean to get into specifics.
Okay.
It was, and I understand that's where you're going,
But
it's more of a.
But you're right. I give that information to them, and I wait for the answer so I can get back to you. And there's always, there's other things that they're looking at, and that's why some of the answers may seem like we're saying no, but we're looking at the policy overall and Oregon Health Authority and other things too as well, that they consider. You said something about as far as the emergency meeting.
No, I just find I find the coincidence. Did you specifically, were you the person that wanted to make these changes, or did someone instruct you?
The bylaws?
Yeah. Did someone instruct you? Who was that someone?
There was talk that they need to be cleaned up, and my administrator said this need to be clarified.
Who was the person specifically that requested that?
Gail.
Yeah. Okay. And so did she have someone else request her that, or was that just her? Or did she say it was being requested by someone else, or was she the? No,
she was looking at how looking at other policies. It's just not like a decision from the top of her head. There's other things that she was looking at considering, and there's other manuals and stuff that we have to also fall up under, and that's why, because it needed to be something spelled out to that was clear, and it wasn't clear in the bylaws as far as being reimbursed for this or reimbursed for that, and how a process is going to happen. And so it needed to be clarified, and then she takes direction from Dr. Bell Combe, who is over public health.
Okay, Sandy and then myself.
Okay, what we're trying to determine here with this request is how much it would cost the patients to fund not only the running of the program, but also pay for these other programs without collecting $3.4 million in excess. And that, we need to know that. We need to know, because the legislature needs to know how much the patients are being taken for. And right now, $3.4 million.
Yeah.
It's way too much, way more than we need for the 6 months that we need to have. And that's why this is so important, that we get this project going, that we find out how much would we really need to collect from patients to pay for all these other programs and pay for all the employees you need. Is there a hiring freeze on right now? And get us eliminated from that since
Yeah.
we're self-funding, we wish we could,
Yeah,
but
but
this is
we
really
have to follow
important, we
everything
need to
with
know, and the
everything.
legislature needs to know. We will not be able to determine that unless this process takes place. And it has happened in the past, so I'm very familiar with it's not that hard to do.
I would like to express my disappointment that Gail didn't make it here. She told me she would when I spoke to her a couple months ago. In fact, I've been attempting to just get a phone conversation with her since July. And in July, she said, "Well, I'm just starting. You know, my job. I can't. I'll schedule you when I can." And then she said she was going to attend the Attorney General meeting, and then she didn't. And then she said she was going to attend our September meeting, and she didn't. I contacted her after that to meet with her. She didn't respond. I contacted her 3 weeks ago to set up a meeting before this meeting. And I finally, her assistant got back to me a few days ago, and with the hopes of possibly maybe getting a phone call with her by the end of the year. And then now I hear that she's going to be leaving in a couple weeks.
That was a surprise to me too.
Yeah, and basically the way this program is structured, the ACMM communicates with the administrator. That's the way the structure has been set up, but she hasn't, and the bylaws, which were originally drafted by your bosses, I think it was DHS at the time, but had established that the administrator shall attend every regular meeting, and she hasn't. I'm very disappointed. I guess I did have some expectations that she would be friendly to our program, but it's just very disappointing. The previous administrators we had, Grant, Jody, Barry, they were all very responsive. Whenever there was an inkling of a problem, they would be on the phone with myself or the other chairs. If needed, they showed up at meetings. They were active. Our meeting with the Attorney General was declared illegitimate, and she never even contacted me to find out what happened at the meeting or the reasons behind it. And she went and ordered a major bylaw revision without even discussing with anybody from the ACMM regarding it. This is just unacceptable, and I would hope that the ACMM would send a clear message to Dr. Goldberg that we need to appoint an administrator that will serve the patients and cooperate with the ACMM. The things I described aren't just, it's not just the ACMM that suffers because of this. We represent the interests of the patients, okay? And since the fee reduction, I don't know if it's just coincidence, but pretty much exactly when the fee reduction went into effect, the fee increase, I'd like to see a fee reduction. Pretty immediately after the fee reduction fee increase was implemented, the services to patients went down drastically. The closing of the service window, the broken promise to implement an online application system by October, our development of research and data reporting ideas with the new database, just all these things, and an increase in the delay of application processing. A lot of this is due to short staffing. I admit, but but I'm just disappointed. And when I see members of the committee, of the ACMM, just questioning why they're even here. You know, we've got a dream team of advisors here. We got 2 dynamite attorneys, 2 doctors, great patient advocates, scientists. We've got a dream team here, and we're willing to volunteer to provide advice to move this program forward in a direction that serves the patients who are the most vulnerable citizens in the state of Oregon. And when these dynamite people who are up here are questioning why they should be here, and when thousands of patients are questioning why they should even show up for an administrative rule hearing, I'm, you know, the canary screaming in the coal mine, and we really need to make some changes in this program and deliver that message to get some better leadership. Okay, Jody Noon was phenomenal. I think she was really good. She was she had the needs of the patients at heart. She was very communicative with the ACMM and other stakeholders. And I want to see somebody like Jody be our next administrator. Stormy.
I have a question for you. It's been several years now, and we should be out of it. Is the mandate to take back the 8.4 million? It broke down to 6.4 million. It was the governor's Senate bill in 2010. Is that right? 2009. What I'm asking is, have we met the mandate now? And even if we don't have the right to set our own fees, do we not have the right now to
At
advise?
3.4, we have, I wrote it down on something, I don't have it, 3, but it's at 3.4, and what's remaining to meet is 3 point something. I have it on my budget sheet. I had wrote out and was looking at it because I have to do all these other project stuff.
You said 3.4 million.
Right now, it's 3.4 million is what we paid out, and so it's like 3 point something left.
3.2.
Yeah, yep, 3.2 is what's left to pay. So we haven't met it, but
Do we have any projections as to when that's going to happen?
I have no projections. We don't want to project because our revenue goes up and down, it's not steady. So it's difficult to predict, and it was directed from the public health director is that not to project for this program.
Jim?
They only show actuals.
Yeah, I believe that when that was passed, it was passed with a sunset clause, or it was going to be done in 2 years.
No, there was no sunset clause.
Well, the budget was for the biennium,
was
so
for
by
biennium.
default, it's not technically a sunset, but it's
But not the fees.
Yeah,
The
okay.
fees weren't sunset,
Thank you.
only
Right,
the
but
amount for that biennium.
Well, but at the end of that biennium, won't it be revisited?
You guys ask me this every time. I'm not sure what's going to happen. I don't have an answer.
Well,
I work hard trying to get an answer too. And I understand your frustration. I can see your frustration, and you point out a lot of good points that are valuable that they're taught. All I hear is that we don't know what the legislature's going to say.
Right,
So-
but we have the statutory duty to advise on the fee structure annually.
Right.
And the program and all other state agencies have the statutory responsibility to provide us with materials needed to carry out our duties.
Right.
And that's not happening. In September, I believe it was it 1.4 million that we had in balance. So it's more than doubled our balance. So last time I believe we passed a motion to the effect of since we haven't gotten any good financial reports, but you know, we were able to say, well, we know that we can decrease the fees. We just want a report from you to say how much and to move forward with a fee increase. But that didn't decrease. Thank you. But that didn't happen. And what I see here is this $3.4 million is a sitting duck for the legislature to just scoop up. And I'd be very surprised if that wasn't done intentionally.
That's right.
And you know, I don't normally speculate that, especially on public record. But I'd be a fool to not believe that it was done intentionally. So, I think we need to move quickly on getting a fee reduction.
You know, I will take this, instead of just sending it, I'll send this up I'll see if I can go over, but I don't have no administrator in the next couple weeks, so I'll just go straight to Dr. Goldberg and get an answer myself.
Yes.
With a letter
Thank
from
you.
us, we help.
Yes, the letter will help, right there, and I will ask that, Todd, if you put in all those things that you see that, what you stated, how after the fee increase, the window closed, well, that was for safety as well, because there was a big risk, and now the whole building is locked down, and everybody says, and a lot of people don't like the building locked down, and everybody says they blame it on me, it's just to want to close the whole building down. It's a joke, but I kind of get like, oh, okay, because it was I know, I ain't too powerful, I don't know about a lot of other things. But that's why it was locked down, because we had a lot of risk factors in the volume of the volume of patients coming to window. People stand there and add up what it costs, and so we didn't want to jeopardize any patients getting robbed or anything happen. And then there was a lot of because it was a large amount of money, we didn't have proper ways of managing money. We don't have the staff to even manage money that are skilled in that. So we had to find some kind of answer to fix that. And as far as and then the database, as far as the database, I have a charter drafted up. I started moving on that myself. So because we need it, and I've met with other people to make this happen. And not be ignored, and to give, even if they don't have the resources to like do, because with the hiring freeze, that also impacts getting contracts too. So it's like an exception. So I said we have this money coming in, we need to provide the service, and we need the oil line system to be put up front, and I have information to support it, because we had an assessment done to our program, so to answer a lot of questions to improve it, and that was a part of it. So I moved forward with the charter and the scope of work to have it happen.
Yes, Alice.
I would like to specifically, as a matter of record, request a timely response based on the fee structure issue that we are moving forward with, want to move forward with. The state of Oregon mandates whenever they request information from us that we have X number of days to respond in a timely manner. We would like to have that reciprocated back to this committee, please.
I also just want to also point out that we really need to have a financial report by someone who's who actually created the report and can answer questions. My memory says it's probably been close to 2 years since we've had someone qualified to answer questions.
Well, Michelle was here. Michelle Cusack, she was here with Jody to report. She came.
Right, but she wasn't able to answer questions. She spit out a report really quick, and the paper report came out wrong, and she wasn't able to answer questions that time. It hasn't been since Chris Grorud was here, and he wasn't even able to attend the last meeting when he still had his job here. And so I could look back, and I wouldn't be surprised if it was 2 years. And we can't give you proper advice without having proper financial reporting.
And last meeting, I asked you guys to send all your questions relating to the budget and stuff, and I would share that with Jeff. The only two questions I had was the ones that you brought up in here, the motion, and that's what I sent to him, which I didn't get answered back. I sent it twice, so if you have questions, I'll send it to him. Because I don't think he's probably not gonna ever attend because of other priorities. And what I can do is just take those questions and get you the answers. And if I don't get them from you, I'll go above.
Sandy?
So I would now like to make a motion that Todd write the letter. And I think it would be good if you just could send it all of us, to send to Dr. Boba, and send it to us so by email, so we have all the points covered, and then send it off to Dr. Boba.
Meaning to accompany Tawana's
Yes,
going directly
absolutely.
there?
Whether Tawana does it or not, we need to do it, yes.
Friendly amendment, I would like some kind of drafting.
That's what I'm saying, if you want to put a draft up, send it to us by email, we can add all the points, and then we can send it off. We've done that in the past, it just would be good.
Okay, all right. And Alice, you seconded?
Yes.
Okay, discussion?
I was going to go ahead and tell you that I would be happy with you since I know I'm behind on this one.
Okay, thank you, Stormy. Any further discussion on that motion? Okay, all in favor?
Aye.
Passes unanimously. Let's take a deep breath.
Yeah.
And Tawana, I know we're directing a lot of frustration your way, but you're the one who's
I know that
the
the
top
liaison
dog
right
here.
now.
So, and
You're the main.
Definitely not being personal.
I know you're being squeezed between us and yeah. So and you're sick today, so thank you for absorbing it. Okay. Anything further on dialogue between ACMM and administration? I have a couple quick things. Has Brendan McCarthy from PGE contacted you? I think he was going to contact Aaron regarding the cautionary statement.
Oh, we can send that out. Yeah, I haven't heard from him directly since that meeting.
Okay. All right. I'm going to report on that further later on. I also have a question. Has the OMMP received any federal subpoenas since 2007? I remember in 2007 they attempted and it was quashed. But have there been any subpoenas since then?
This might be an issue where I'm just not certain this is the role of the ACMM to ask these questions of us. I mean, it may be, but I don't have an answer to that. I'm not sure I can answer that question. I apologize, but I just don't know that these are the kinds of questions that you're in place for.
Why not?
Why not?
I mean, where in the statute are we going to answer a question about whether we've been subpoenaed by the federal government? That has nothing to do with the fee structure.
Administration of the program.
It's not that.
Yeah,
See what that would
So part of the administration of the program would involve, if the administration of the program has to answer subpoenas, then how the program is administered.
I don't know the answer to whether that's public information, and so I'm not comfortable
And that's a
answering the
separate
question.
answer, because they do issue secret subpoenas, I understand that. But I only responded to, of course it's within our purview to ask almost any question about the administration of the program.
Right, you can ask any question, but we do not have to answer those questions, and I don't think that is an administrative aspect.
My expectations are very low, so I'm not
I'm happy to pass these questions on to people with the authority to answer them.
Yeah.
Well, ironically, we have somebody in about 10 minutes, so.
Yeah. Yeah, because I remember when those subpoenas did come, and when the what's that congressional investigation body? The program. I think it was when Mary Leverett was here. They were very upfront with us about their visits from the federal government.
Wasn't it?
Maybe it was
It
Pam?
was Pam,
Yeah.
yeah.
They're very forthcithing with us about
Right,
those.
there's a lot of things that
And-
some have taken actions on to where they shouldn't have taken action on or stated anything. And like Aaron said, I don't see that as an administrative aspect, or an advising, that's raising a question about something legally. And like Aaron, I wouldn't respond to that either. I'll let him take that question back to the person that does have authority to do that. And so,
'Cause
and what others did in the past, there's a lot of things that happened in the past that was outside of the scope, and also wasn't the right choices. There's things that was against policy and everything, and that's why right now we're looking at making sure that we're doing everything by the law and everybody is following policies as well. So, I think that I'll let Aaron take that back to.
Yeah, I'm more than happy to answer
I don't
that
think
question. I
we
just
should
don't
answer
have an
that
answer.
right now.
I don't have an answer.
What specifically do you think in the past was done outside the scope?
There's a lot of things that's happening, and I'm finding out, so, and I'm not gonna share those things, because it's not even a need for you guys to know what that is.
Well, the reason I ask is because there's a lot of that occurring right now, mostly in California, where the U.S. attorneys are subpoenaing registry information for both patients and growers and dispensaries and et cetera, with the intent of causing harm to otherwise law-abiding citizens. And that is a serious concern of the ACMM, that the way you administer the program is protecting the patients that are covered under this law. And so I think that is firmly within the ACMM's scope to learn those things. But we could move on. Okay. I also just wanted to, okay, actually, I'll save that for next time. Our next point of business is to schedule the next meeting. I've been trying to...
Dr. Goldberg did respond to you.
Yes.
So.
But somehow I recall someone coming up with a reason that we need to meet somewhere else other than Salem in the spring.
Because we set history, because when we set it all up, we said we would meet in another location besides Salem and Portland at least once a year. And we've been down to Bend, we've been to Medford, and we've been to Newport.
What's the mean?
What?
Yeah, I'll second that.
That would be great.
We've done
The thing is finally, I've got a positive response from Dr. Goldberg, and he gave us the date of March 11th, where he would be available to attend our meeting in Salem.
Salem.
His main office is in Salem, correct?
Dr. Goldberg, yes, he used to come out here, but I haven't seen him here lately. So much stuff keeps changing.
So do we feel it would be worthwhile to meet in Salem for the purpose of meeting with Dr. Goldberg? Okay, Stormy?
If I vote yes on this, I'm just get on Syria this summer. It's really pretty over there, you guys, everything blooms.
Oh, I bet it is.
I mean,
Yeah.
I come over here every single time. You guys don't get anywhere close to where I am. So how about we come over in the spring?
So I'll go on.
What do we?
Tell me about that.
I'm the closest.
Yeah.
And it's 6 hours, 25 minutes, really.
Is Klamath Falls any closer for you? Or because I think a lot of people are psyched about Medford, but.
Haven't been to Medford in 3 years.
Are we
They've
talking about
never
meeting
been
in
down
March?
there
March is
yet.
supposed to be in Salem.
Yeah, no, we're talking about the June meeting, I think.
Oh, the June meeting.
Yeah, spring.
That's when then we go
Newport.
somewhere.
But yes, I will go for that, to see Dr. Goldberg. That would be
March
great.
11th.
But I definitely hear you, Stormy.
So March 11th.
My
It must be tough being in
Wawa.
that
I mean, he's
corner.
this big, he's been across the state 43 times.
Mhm.
He's only 7 years
March
Okay.
11th, is that?
So March 11th, is that looking good for people's calendars?
What day of the week is that?
Monday.
Monday?
Yes.
Ryan, is that a Monday? Big court day for you, but. Okay. So any objection to March 11th in Salem?
So,
The only thing is that hopefully we can get a room. That's where our problem is.
Sure.
Maybe a VCON.
Yeah, and I guess Kaiser would be fine too then.
Salem or Kaiser.
Should we assume that, Todd, that you would, from now on, always prefer a VCON room? I mean, I know we haven't gotten this set up and I'm not certain how to do it, but at least should we look for the room?
Yeah, I think making every opportunity to allow video conferencing would be great. And maybe if we're able to use the system once, it'll improve things. But it would be good also to look for other ways that we can possibly video conference or such. I know that there's technical problems with the phone. It hasn't worked in the past, but yeah.
It's likely the better of us to set up the meeting, so I just want to make certain that the person setting up the meeting understands how important that issue is.
Sure, appreciate it.
Dr. Cohen suggests March 11th is good for him, by the way. Yeah.
So we do almost have two-way verification. Okay, so anyone want to
Make a motion?
make the motion?
11th?
I second that.
Second the motion. Okay, all in favor?
Aye.
Okay, March 11th in Salem.
It's one of those motions that's going to get acted on.
Okay.
Also, he also favors the technical conferencing as a person who is currently not able to. Likes that.
Thank you, Dr. Cohen. Proxy there. Okay.
If Dr. Goldberg discovers that for some reason he's unable to attend, can you somehow request this to let us know as early as possible so that we can reschedule to accommodate his changing schedule? Because I think that's the primary reason to have any date around that area. And so we would do what we can to accommodate his movable feast, as it were.
I don't see Amanda here yet. We still have a couple of minutes before 11. Anything else we want to drill into?
You want to do the bylaws while I'm here so that I don't have, so I could not be here this afternoon?
I'm sorry, can you?
Can we do the bylaws now while I'm here?
Sure, and we'll work on that, and if we see Amanda come in, then we'll shift over there. But yeah, why don't we do that?
Does everybody have a copy?
Yeah, does everybody have
It
a
wasn't
copy?
in the packet.
Yeah.
Yes.
Okay. Do you have a copy to look at, Ryan? You do? Okay, great. Maybe we could start with Tawana giving us a little background about, we mentioned it a little earlier about, who
Yeah, so,
and the reasons behind it.
because there was some confusion and not clear about a special meeting and how the process is to request a special meeting, wasn't outlined clearly in the bylaws. So, I was directed to draft language to address the process of how the ACMM would request a special meeting. So there's clear direction and no misinterpretation or misunderstanding, and I think that's what happened the last time, because it wasn't a clear process. And so I drafted that language, and then there was discussion around the statutes, and then other statutes that may involve meetings and public meetings, and then Gail and I were discussing it, and Shannon was involved as well. And when we were discussing it and changing it, there was other areas that was not, that wasn't consistent and clear. So we just went through and clarified just some housekeeping stuff in the bylaws. But we mainly was trying to stay within the guidelines of when the person's reimbursed for travel and stuff as well, and getting paid for meetings. So we wanted to clarify when the committee would be reimbursed for the travel, as well as having a special meeting. So that was the only thing that we were really, and then the cleanups in the other areas. Is this the version that I put out?
No, it wasn't clear with the color coding what was deletions and what was insertions, so I clarified it, and these are my comments.
I didn't send it with the changes. I thought I put in a PDF file with the changes.
Yeah, you did. There was just a color coding scheme that was not clear, so I made this clear for myself.
Oh, because of what I did to what Shannon did, and those different colors for each. Okay.
Right. Yeah. So
I thought I tried to clean that up for you. I apologize. I wanted to make it clear so that you could see it.
that's okay.
I thought I took the colors off.
Well, I see that our special guest is here, so we could move this back to its originally scheduled time, unless we could do it first, right after break. That would help you out.
Yeah, that,
Okay.
I'll stay right here, but I'm just need to.
Okay.
Real quick. I'll be right back.
Whatever you guys are more
So-
comfortable with.
Great.
Do you have, would you like?
A mic, yeah, get her a mic and a seat, whatever else she needs.
Hi, Lee. Nice to meet you.
Well, good afternoon.
Hi.
Thank you for coming. How are you doing this morning?
I'm good. How are you?
Doing well. Just wanted to introduce our U.S. Attorney for the District of Oregon, Amanda Marshall. Would you like to introduce yourself?
Sure. I'm Amanda Marshall. I'm the U.S. Attorney for the District of Oregon. I've been the U.S. Attorney since October of last year, and I was invited to address a group today, and I think primarily to answer questions. I do want to say preliminarily before responding to any questions, and some of you have heard me say this before, but I cannot comment on any pending state legislation. I can't comment on state policy. It is clearly not the role of the United States Attorney to influence politics within the state of Oregon. So that can be a difficult discussion to have in the context of this, and when I was asked to speak here, I was hesitant to do so because I think it's difficult for me to honor that boundary, and it's an inclination that people have to want to engage in questions like, and I've had a lot of these conversations in the past year, what if we amended the statute so it said blank? Would you prosecute people? And I can't weigh in on that type of analysis. But what I can do, and what I said when I was called and asked to speak here, is that I am happy to give people an idea of the abuses that we've seen since the passage of the Oregon Medical Marijuana Act, in terms of people who, and it's difficult because people will say, well, you're prosecuting medical marijuana cases. And of course my response is, no, we haven't prosecuted a single person for the medicinal use of marijuana. and we have not prosecuted a single person for operating within the Oregon Medical Marijuana Act. We've prosecuted a lot of people who are dealing drugs under the guise of the Oregon Medical Marijuana Act and hiding behind the state statute and using it as a defense. And some of those people may also be engaged in delivery of cannabis to patients, but that's not what they're being prosecuted for. They're being prosecuted for profiting from drug trafficking. I can certainly talk about what we've seen and what those cases are. Most of that information, I think, has been pretty widely reported as a matter of public record, but if folks have any questions about how our office decides to prosecute somebody or what kind of factors we consider, people have asked me why we're targeting medical marijuana, and I've tried to make it clear that in fact we're not. It's not one of my priorities, and it's not a priority for the Drug Enforcement Administration. It's not a priority for any state, local, or federal law enforcement agency that I'm aware of or that we've worked for and with in Oregon. But what happens is, particularly in Southern Oregon, where the grows have become so rampant and the money has become so tempting, where pot sells for $5,000 a pound on the East Coast, is that while law enforcement is looking for methamphetamine, heroin, and the illegal trafficking of firearms, they're tripping over kilos and kilos of marijuana, much of which is on its way outside of the state of Oregon for sale to people who are not Oregon medical marijuana card holders. So that's my perspective from a law enforcement perspective. I know a lot of people want to hear about the legalization initiatives. Sometimes I get confused because I don't know if this body cares about that, but to me it seems like a completely separate issue from medical marijuana. And all I can tell anyone who did want to ask me that question in advance is we don't have any idea, and we're waiting for the AG to weigh in, and I have no inside knowledge other than what you've all probably heard on NPR, if you know, or wherever else you get your news. So, the Oregonian or the AP. I want to recognize everybody that might be a source of news, but so I'll just say those things preliminarily, so you know sort of what I was thinking about when I was driving over here in the car. And aside from that, I just wanted to be available to clarify anything or answer any questions that you have. Jim? Yeah.
I'm not sure if this is an improper question or not. I'd like to know what is the relationship with the state's Attorney General and the State Attorney General, Ellen Rosenblum, as far as just collaboration on, do you stay away from things that fall under the 10th Amendment, or is there, how do you work that?
The 10th Amendment is the subject of semester-long law school classes. So it is not a bright line. Everyone agrees. It's very clear. I certainly have an understanding of the 10th Amendment, and I don't know if you know this about me, but I've spent 1 year as a federal lawyer, and I spent 18 years as a state lawyer. So I think I have an appreciation for state law, and it's part of the reason that I make a practice of staying out of state politics as the U.S. Attorney, because I don't see that as my role. That said, to me, there is a preemption doctrine, and federal law can preempt state law to the extent that Congress has passed legislation that applies in a particular field. In terms of your question about Ellen and I think Ellen's fabulous, and we have a great relationship, and we talk regularly, and we have sat down and talked about Oregon medical marijuana. I've shared with her the excesses and abuses that we've seen, the increase in illegal drug trafficking through the mail, over land, in every mode you can imagine, and the increase in DTOs operating in Oregon that we believe is directly associated with the passage of OMMA. Now, what she does with that is up to her, but we think it's important she has the information. She was fairly receptive. I know that there are several conversations that are going on, some that have included the Attorney General in reference to potential amendments to the law or working with the legislature to address the issue of overproduction, which has been the primary issue that we've seen in these cases. And you know, I think Ellen Rosenblum is a fantastic AG. But what I can tell you is there hasn't been any discussion that at least in terms of the District of Oregon in my office, I haven't heard anybody suggest that we are in violation of the 10th Amendment or overstepping our authority as federal law enforcement when it comes to the particular cases that we have prosecuted in the state of Oregon. That assertion has not been made to me by anybody in state government. So I'm not sure if your question is in terms of a specific enforcement strategy taken by the federal government in Oregon, or if it was a more general question.
Thank you.
And maybe we could introduce ourselves when we speak.
I don't have a place card. I'm the low-level person on
You don't even merit
That's what we do with our attorneys.
Yeah.
It's not a coincidence. I mean, I'm a practicing attorney on the board. We deserve a little lower level, but they have one. The way I joke on. But my name is Brian Michaels, and I am an attorney here in Michigan and in Oregon. Excuse me.
Oh, I get it.
In
Wait,
Oregon.
no.
And then I have a couple of questions for you, but I want to comment on your opening preliminary remarks.
Yeah.
And although I don't really have any comment in terms of criminal prosecutions to what you said, in terms of your forfeiture proceedings and your seizure of money and other property, the pleadings you make in your federal complaints for these forfeitures, when applicable, use medical marijuana as a factor for probable cause that illegal transportation of drugs across state lines is occurring. So that I have several cases where there's money that's seized, and they look it up illegally, by the way, by a state case called Hale v. Hanlon, which says you're not allowed to look it up for the detriment of the patient. And they look it up under the LEDs and OMMP records to find out that the recipient or sender of the money is a medical marijuana card holder. And then they use that as probable cause in the affidavit that gets the complaint. So it does seem to me that, and I have no comment on your criminal prosecution remarks, but I don't think that really plays out in your civil forfeiture.
There's two things I want to say. One is I cannot comment on any pending case. And to the extent that you're a party to a case, I certainly can't comment on a pending case that you're an attorney on that involves my office. But secondly, I would say that we have only, to my knowledge, initiated 2 civil forfeitures in the state of Oregon, and I believe they were both initiated in early November of this year that are directly related to Oregon medical marijuana. And so, you know, so that makes me even less likely to want to comment because I don't see it as something I can talk about generally because the pool is so small, and you're an attorney on those cases.
I will tell you that I was contacted because I have 1 or 2 of those cases.
Where we filed complaints?
By a report, yeah. By a reporter for the Mail Tribune who was doing a study on medical marijuana and civil forfeiture in the state of Oregon for the past 3 years. His last name is Freeman, and you might want to talk to him. But there are many cases that are not my own that seem to have, in his research that seem to have this same pattern. He contacted me because I had a case that had the same pattern. And so I just wanted to respond to your preliminary comment with my preliminary comment. I know that there isn't anything you can answer, but I just didn't want to let it go unanswered because it didn't fit my experience in the civil forfeiture case, and it didn't fit other people's experiences as well. And if there's something we can discuss about it some other time, I'm more than happy to do that.
Yeah,
I
that
understand
would
this is not-
probably be better, because I can
understand.
tell you, I mean, it's not been my experience, and this is a folder where we have, you know, every dispensary that's been identified in Oregon, and we've been tracking, and we've been, you know, trying to decide how we're gonna respond, and as I'm sure that many of you know, we've been much more restrained on the civil forfeiture end in terms of taking action than most other districts that have legal medical marijuana.
It's a hit and miss. Some have been much worse than this, than Oregon, some have been as good.
And that's intentional, and I've been directly involved in those conversations, so I know it was with great thought, you know, and deliberation that we filed 2 civil forfeiture actions that were directly related to people who were selling, you know, who argued that they were selling medicinal marijuana in compliance with OMMP, and that was not our perspective. But that there were 2 actions filed in November, and generally the policy of our office is, unless there is something that we will be able to prove that shows that the actor is operating outside of what is allowed under OMMP. The DAG has issued a memo, and I'm sure that your group has talked about it, the Deputy Attorney General of Policy for the Department of Justice, and I've worked very hard to be compliant with that memo, to the extent that in the first federal prosecution in Oregon, in a jury trial, for somebody whose defense was Oregon medical marijuana. Again, I don't like calling them Oregon medical marijuana cases, because I believe that these people are criminals. They're not people who are acting consistently with the state law. But in that case, we made a choice, my office made a choice, and the prosecutor, specifically Doug Fong in Oregon, made the choice to introduce the Oregon Medical Marijuana Act and to affirmatively show to the jury that not only was the defendant in violation of federal law, but that the defendant was also in violation of the Oregon State Medical Marijuana Act. And that was a controversial decision, because, you know, there are certainly those who would argue that, hey, you know, the 10th Amendment question, federal law trumps state law. You know, we have preempted in this area. It is a bright line. It's pretty clear, I think, when you're talking about the Controlled Substances Act, that we preempt. So we don't even need to, well, you can shake your head, but legal scholars can differ. But
Supreme Court disagrees. Oregon Supreme Court disagrees.
we will, and we'll see what the U.S. Supreme Oregon. So we could have taken that position, and other people have taken that position, that when it comes to the decision being made to prosecute a case federally, we really do not, we don't need to discuss state law in federal court when we're prosecuting these cases. We didn't make that decision. We said this is Oregon, and we do want to partner, and because the DAG memo did say, even though the DAG memo is a policy decision, it's not it doesn't restrict what I can do as a prosecutor in federal court. In the spirit of that, and in the spirit of really wanting to be transparent, we wanted everyone to understand, and the community of peers that were judging the defendant in Southern Oregon, we wanted everybody to understand that we had considered the state law, and that we had considered the DAG memo, and that it was only because, as the memo states, that we believe that these defendants are not clearly and unambiguously compliant with state law, that we made the prosecution decision. And so on the civil forfeiture front, we follow that as well. I mean, that's been our policy, is that if people are clearly and unambiguously, you know, in our opinion, to the best that we know from our investigation to a probable cause determination, compliant with state law, we're not initiating civil forfeiture actions. I mean, as you all know, there is over 100 dispensaries operating in Oregon, and, you know, to my knowledge, we've filed civil forfeiture actions on 2 parties, only one of which involves a dispensary. So, you know, we take that seriously, and it isn't our intention to go after people either civilly or criminally who are clearly and unambiguously compliant with state law. Now, people can there's a lot of room for argument about what that phrase means, and I get that, but that's been our practice.
I'm just going to dwell on for another minute, because there was a miscommunication, and it's probably on my part. what I was trying to say is that there's a lot of mail or package interdiction going on.
Yes.
And a lot of cash is
Okay.
taken.
Oh, yeah. So
Yeah,
postal
I wasn't
service.
talking about dispensaries.
Okay.
And so, when cash is found, and we don't wanna get into how it's found with the dogs and all of that.
Yeah,
because
yeah,
that's
yeah.
not a-
Okay, this is
but
something totally different.
I know,
Right,
I
got
understood
it.
that when you went to dispensary, I realized I was not as
Okay.
clear. These are just individuals who either were receiving or sending cash and got
Yeah, yeah, yeah.
addicted.
Yeah.
And if then they go in and they look to see whether the individual is a medical marijuana card holder, which is an
Okay.
illegal use of the system by virtue of Held v. Handling. Because the system can only be accessed by law enforcement for the betterment or protection of a patient, of a card holder, to prevent an investigation from consuming a criminal investigation, in other words. Your neighbor calls up and they smell marijuana, the cops come over, they see there's marijuana grow. They call LEDs, they call OMMP to say, okay, is this a grow site? And if it is, they stop the criminal investigation. So it prevents a card holder from being incorrectly targeted for search warrant. But in this case, they're accessing the information, and when they find out that it's a medical marijuana card holder, they use that in their affidavit to get a complaint. That was my point earlier.
Okay.
And I think it's a hostile attitude toward the medical marijuana program in the sense that there's a presumption that somebody who has a medical marijuana card is a criminal. And that presumption is the hostility I was trying to respond with. With that said, I'm going to go on to my next thing. Earlier, before you were here, the Oregon Medical Marijuana Program representatives were asked, not by myself, whether or not you had issued subpoenas to the program. The Medical Marijuana Program representatives felt that it was not for them to respond, and they did not. And quite, coincidentally and favorably, here you are. And so, I'm wondering.
I wouldn't comment on any pending investigation.
No, I mean, just a random, is the Oregon Medical Marijuana Program a target of any investigation, or are you using subpoenas against the program, or you just can't say?
That is such a catch-22. If I had a pending investigation with anybody in the state of Oregon where there was no public record of an indictment, I could not comment on that. So I can't comment that there's not, because then that would be, so I'm in a catch-22 on that. Yeah.
I do appreciate you coming here and putting yourself up to all of this. It's a quite remarkable one. Thank you very much.
Well, I get to spend the rest of tonight with a bunch of Oregon district attorneys at their meetings, so they'll help me to build my ego back up.
And speaking of ego, I'm happy this may be my only opportunity to preside over the U.S. Attorney, so please indulge me. I wanted to comment on something you said in your opening statement. You're wondering if it was interest to this committee to discuss any of the legalization initiatives or concepts. And speaking for myself, I would say yes, very much so. We hear a lot that the Oregon Medical Marijuana Program exists because of patients who need medical marijuana. But really, this program exists because there is federal and state prohibition of cannabis. So the landscape of federal and state prohibition on use, cultivation, et cetera, of cannabis very much impacts the Oregon Medical Marijuana Program. And if prohibition didn't exist outside our borders, medical or not, then you probably wouldn't find any criminals, because the activity of selling or distributing or being out of limits wouldn't exist. So that being said, of course, the prohibition outside the state borders definitely impacts the behaviors of patients here. So I just wanted to comment on that.
I'll just say I disagree with that. I mean, because alcohol is legal, And we prosecute people for furnishing alcohol to children, for driving under the influence of alcohol, for all kinds of things. And my understanding of the legalization proposals that passed in Colorado and Washington, both of those statutes include significant regulatory oversight and limits. And so I expect there would still be all types of crimes that were prosecuted, and they also put limits on people's ability to profit. And so, you know, it's difficult for me to envision a legalization and regulatory scheme in which there are still not abuses, and there's still not, and to the extent that like the other laws, not like Oregon's law, which was far more, statute that didn't have, which is far more permissive and contained much less regulation and much more of an opportunity for individual profit. The other laws restrict that to the extent that, you know, potentially there still would be a black market. So anyway, but go ahead, I just didn't want to leave that like that was just the end of the conversation. If it was legalized, there would be no more criminals. I mean, I don't know if that's accurate.
Yeah, I agree mostly with what
Yeah.
you just said, yeah. And a legalization to me doesn't mean, you know, chaos or all-out free-for-all. You know, legalization to me means there's a regulatory framework, and certainly there will be crimes, you know, if we saw legalization here in the state. I guess with lack of uniformity of state laws and with federal laws, I think that is probably the heart of the problem that
that
keeps you busy.
100% on that.
Yeah.
Yeah.
So, so with that said, I was wondering if you had any discussions with Eric Holder or any of the Washington, D.C. DOJ.
You know, Eric and I don't talk on a daily basis. He did say I could call him Eric. I'll tell you how that works though. There's like many issues. I mean, as you can imagine, the Attorney General is an incredibly busy, overwhelmed person with what I have come to believe has got to be one of the most difficult jobs in the entire world. That said, I do have opportunities to meet with the Attorney General, as do all U.S. attorneys, and but those opportunities are somewhat infrequent and are very targeted in terms of the discussion. The way that U.S. attorneys communicate with the Attorney General is through subcommittees that are advisory to the Attorney General on individual topics and working groups. And so subcommittees tend to be longer term issues for the Department of Justice. For example, I'm on the advisory subcommittee on Native American Affairs. That was one of the original advisory committees to the Attorney General, because the United States has always had a particularly challenging and unique and interesting jurisprudential relationship to tribes. So that's an important subcommittee for those U.S. attorneys who have Indian country within their borders. Medical marijuana is obviously a newer issue, so it's not a subcommittee, but it's a working group. So it's formed initially, it may become a subcommittee. I think the hope is that at some point this issue will become resolved one way or another, and we can stop having to reporting to the AG on it. But so all of the states that have legal medical marijuana are the U.S. attorneys for those districts are represented on the working group, and we meet regularly. In fact, for some period of time, we were meeting frequently and broke off into two different meetings. One to discuss policy and criminal enforcement, the other just to discuss civil enforcement. And we've now combined those back together. And so John Walsh, the U.S. attorney from Colorado, is the chair of that working group. You know, all of the U.S. attorneys in California are represented. I've been very active on the group. The U.S. attorneys in Washington are represented. And there are also U.S. attorneys that are part of that group that just attend because they have the potential for legal medical marijuana and they want to stay informed in the process. For example, Boston, Carmen Ortiz, Massachusetts, they had the ballot measure, and so they were participating in the working group. And then there's also been participation by other U.S. attorneys who are source states for marijuana coming from medical marijuana states that are significant recipient source states for the shipment out of marijuana from primarily Oregon and California and Colorado. And so we get together regularly with those U.S. attorneys, and we have roundtable discussions where especially the most active districts, Oregon being one of them, gives a report at each of those meetings. This is what's going on with Oregon. These are the cases that we've indicted. This is what happened in our jury trial. This is the jury instruction the judge gave. This is, you know, whatever the issues are, legal, how we're handling them. You know, when U.S. attorneys were first initiating significant civil forfeiture action, we would get the report from, say, Melinda Haig in San Francisco to say, I've decided that in my district, I'm only going to be targeting those dispensaries that are within 1,000 feet of a school or a playground. That's how I'm going to try to limit, you know, our investigations. And we would all talk about that. You know, is that something that we would like to do? Is that a good idea? But we make an attempt to, well, we try to be sure that we're all informed about what everybody else is doing in every other district, and that we have opportunities to talk to each other, and we make a real concerted effort to make sure we're within the realm of consistency while recognizing that each district is unique and that U.S. attorneys have some discretion to make policy decisions within their district, and especially as they relate to their particular use of resources and their priorities within their district. And then that information is communicated back to the Attorney General through John Walsh, who is also a member of the Attorney General's Advisory Committee that meets personally with the AG's office, either monthly or bi-monthly, depending on their schedule. And they have an agenda they go through, and part of the agenda is the report from the advisory committee or subcommittee on a particular issue in that dialogue. And then the folks on that committee are a resource for the Attorney General's office, either, you know, Mr. Holder personally, or the Deputy Attorney General, or other components within DOJ, say Lanny Brewer, the Chief of the Criminal Division, whomever it is that may have a question or an issue, or you know, a call from a legislator in DC about a particular topic, they would know who to reach out to get the answer. For example, when the Attorney General recently sat down with representatives from, including Blumenauer, and some other folks in the congressional delegations of other states that had medical marijuana, to talk about DOJ policy. Then, before that meeting, they reached out to me, they reached out to John Walsh and a couple of other U.S. attorneys so that we could brief them on the cases that we're doing, what's going on in our states and what the issues are. So that's the way that dialogue happens.
Good. So then you would probably have a great deal of insight as to why the U.S. attorneys of California are so aggressively pursuing prosecuting and forfeiture on some of the model dispensaries that are compliant with state law.
You think I'm going to comment on cases that Melinda and Andre are doing in California? There's no way.
But there are a lot of them, so it would be very general.
Well, they have a lot, you know, and they're bigger states. They're extra large districts. They have many more dispensaries than we have, and they have had a much bigger issue with DTOs in California than we've had in Oregon. So, you know, I mean, that's what I've gleaned from the discussions I've had, but, you know, you'd have to talk to Melinda and Andre if you want to find out, and Ben and Laura if you want to find out why they're taking the cases they're taking.
Sandy?
Well, I just, what you just said, dispensaries in California by state law are legal, are they not?
I really don't want to get into a conversation about California law.
Well,
I mean,
Oregon,
right,
it says
right.
No sales. I
Right,
mean, I
right,
agree with
right.
that. But
Well, you
California
and I are
has a
maybe the only two.
completely different setup, and you were kind of comparing them a second ago.
Well,
so-
I mean, I just, that we're all on the subcommittee, and we all have really different laws, and we all have really different issues related to the laws and, you know, what's going on in our district. So I can't comment on what they're doing in their district, you know, but I was just trying to explain the way that we communicate with each other, and try to be supportive of each other and be consistent. By consistent, I don't mean that we do exactly the same thing, but that we're sort of talking about the thought process and the values that are driving our decisions.
I understand, but you said earlier that when you were looking at the law, the federal law,
Yeah.
you also looked in some cases at the state law.
I do, that not
Yeah.
everybody, I mean, I think everybody does look at the state law, and the DAG memo does say, you know, as a general policy statement, that the Department of Justice won't be focusing on people who are clearly and unambiguously compliant with state law. I can't tell you, I mean, I understand that there may be people who would argue and have argued, and I read the national press, that the dispensaries who have been either prosecuted criminally, where there's been criminal or civil forfeiture action in California, were compliant with state law. I don't know that that's the perspective that you would hear from the U.S. attorneys in those districts, but I don't want to get into an argument about those particular cases. And just because it's legal under state law doesn't mean the practice of an individual party was legal in the way they were carrying out in a given instance. I mean, certainly it's never legal to ship pot to the East Coast and sell it for $5,000 a pound, even if everything else you're doing is legal. Yeah.
And then, yeah, just to follow up on that, you said that basically that, you know, that you have a thought process that drives your decisions,
Yeah.
and others do too, and that there's clear and unambiguous. Could you define what is clear and unambiguous by your definition?
You know, when you see it.
Wow, that's a surprising
To
insight.
quote,
Yeah.
Chief Justice. No, it is really difficult. I mean, it is, it's hard to, I mean, I can certainly talk, I think a good example is United States versus Nelson, which is a case I'm comfortable talking about because the verdict is in and sentencing has occurred. But in that case, and it's a matter of public record, in Southern Oregon, it's an overproduction case. And when we first went in and decided to prosecute that case, it was a case that was different than some of the state prosecutions in that on the face of it, you go to the grow operation and it's, I have 100 cards. This isn't factual. This is a story to illustrate a point. So this isn't actually Mr. Nelson's case, but something like I have 100 plants, or I have 100 cards, and I have 600 plants. I have 6 plants per card holder, which is what I'm allowed to have. So go away. And I think what had been happening was that local law enforcement had been going away. Counting up the plants, counting up the cards. You shake your head. No one's gonna ever agree with everything I say. And again, this is to illustrate a point. This isn't the facts of the case. But generally, there were challenges associated with prosecuting those cases because, OMMP says you can have X plants per patient, and that's what I have. So that's the end of the story. Even if these plants look like, trees, and each one produces 8 to 10 pounds of manicured smokable bud, and you can only have 1.5 pounds between the caregiver and the patient at any given time of usable product once it's harvested. So that didn't make a lot of sense. And so Doug Fong and the law enforcement agency he was working with down there, designed this strategy to prove that defendants that produce this much marijuana are in fact producing it for profit. It's their intent. They're not there to, I garden. It's a lot of hard work. Those are beautiful plants. These people are brilliant gardeners, and it is not by accident that they are producing these amazing horticultural achievements. And so, and they're spending lots of time and lots of energy on cultivating these huge plants that are so productive. And so Doug, took the time to sit down, figure out a way to statistically extrapolate what would be a significant population of the grow in order to show the overproduction and the amount, the quantities and the money. And then very methodically, I think, went through and did that in that trial that led to the unanimous jury verdict, even with the judge giving an instruction to the jury that it was the government's burden to disprove that the defendant was compliant with state law, and to disprove that the defendant had relied on President Obama and Attorney General Holder's policy statements about enforcement of medical marijuana. So even with all of that kind of stacked up against the government, you know, the jury was able to see their way clear to conviction. So that's an example of us looking at a case and saying, okay, if the defendant has the amount of plants, you know, at first glance that OMMP says he can have per card, but look behind that and make the determination. You know, at first glance, he may look like he's technically compliant with Oregon state law, but he is not clearly and unambiguously compliant with Oregon state law. Yeah.
Jerry? Introduce yourself too.
Yeah, my name is Jerry Lehrberger. I apologize for being late. It was quite stormy down south. So thank you for going into the detail that you have. I really appreciate learning about some of the committees and subcommittees and the hierarchies and all that. So I really appreciate that. There's a lot of technicalities and a lot of skirting around issues is what I'm appreciating. We're looking at different laws in different states, different landscapes in different counties. The topography and landscape are very different. We have networks of people coming together and meeting. What is the one theme that brings everybody together? If you could bottom line it, is it money? I know it's state law and breaking laws and 1.5 pounds or 2 pounds, or depending on the region. And you know, clearly laws are being broken, and clearly we're trying to serve patients. But what is it? What is the one bottom line that brings everybody together? Is it money?
I need clarification on what you mean by bring everyone together. Do you mean
what is the major issue if you could bottom line it?
That makes somebody get prosecuted? Is that what you're asking, or? Because you're comparing quantities to cash, and I'm not sure what the.
No, not really. I'm just trying to get even beyond all that, because there's technicalities, and we're breaking the amount of cash, the amount of plants, and the amount of plants per individual, and you know, all of that. But is it really the illegal use of what is perceived as the illegal use of money? I'm just trying to understand.
What makes us care about prosecuting it? Or I still am not getting what you mean by brings everybody together.
Well, I mean, I'm just wondering what the major issue is. Is it money? Is it that people are profiting? Is it that money is not being redistributed into a different sort of system? Is it money? I apologize for my naivete.
Can anyone else help me? Thank you.
I guess what I hear you saying is it's sort of back to what are the driving decisions? What drives? I think so. What I hear is, correct me if I'm wrong. What I hear you saying, one of them is overproduction. The other one, what I hear you addressing when he says money, I think is consideration versus reimbursement, right? And then you know, there's a whole list of clear and unambiguous. So the question is, you're saying overproduction is clear and unambiguous.
It has to be clear and unambiguous.
It has to, and so it's easy.
And if you got a couple ounces over, I mean,
no, but let's say you have a 8-pound plant,
right.
You give away for no reimbursement or consideration 6.5 pounds of it, right? I mean,
okay,
I
want to say a couple of things. I think I get it now. I think both of you together have helped me.
But I want to say one more, because you said you know, people are profiting from this, and so that's why I'm jumping to that conclusion. People are profiting. Is that the major issue?
Okay. All right. There's a couple of different things I want to say. One is that there's one question that I'm hearing that's about that's almost sort of like, what do you guys really care about this? And for me, and I can't speak for everybody, but I can say this is certainly a theme that has developed in our discussions and working group. the concern isn't that people are smoking marijuana. The concern, and not to say that there aren't concerns associated with that, but that is not what's driving it. The concern is that what we see some patterns that develop as a part of drug trafficking. And I think, I think the debate has moved in a progressive and forward-thinking and positive direction over the whole issue of the drug war, not just marijuana, in the course of, whenever I went to law school, the last 20 years. But to a recognition that substance abuse and dependence it should be looked at more of a public health issue than a criminal justice issue. I hope that's not terribly controversial. But the problem is, and I know the answer to this is going to be, what you said. Well, it's because of prohibition. But I'm not a policy, and I love the Constitution, and I am really happy that I understand that my role is as a member of the executive branch and not the legislative branch, and that's. And so I'm not here to talk about what the best policy would be. But what I am here to say is that currently, because of the laws that we find ourselves with, because of my role as U.S. Attorney, which is to enhance public safety and prosperity and equal opportunity within the state of Oregon, that where we find ourselves is that people who find profit in the illegal distribution of drugs, whether it's marijuana or heroin or methamphetamine, those people don't look a lot different in terms of the other things that they end up doing. So what they end up doing is tax evasion. I think every single grow operation we've gone into has been replete with firearms, many of which are illegal by nature of sawed-off shotguns, barrel the wrong size, certain types of assault weapons that need to be registered or you need to be permitted that they're not. Not all of the guns are illegal, and of course in Oregon, I want to be careful here, Second Amendment, we can have guns and you don't need to register them. So that's not what I'm saying, but I'm saying that I think that some people in Oregon have had a perception that if you're growing marijuana, you're different than every other type of drug dealer. And so we're concerned with drug trafficking organizations for a variety of public safety reasons related to firearm trafficking, related to tax evasion, related to all kinds of other problems that we associate with drug trafficking organizations. And so that is a problem for me as a U.S. Attorney, and that's why I care. Now, in terms of what triggers a federal prosecution, there are many different things that would trigger it. So, for example, there are certain thresholds that relate to quantity, and delivery of a controlled substance is in itself a crime, whether or not there's consideration. Consideration is an additional factor, and certainly consideration for me has been an important decision-making point because it helps to illustrate that someone's not complying with OMMP, which is one of the things that I want to show before I initiate prosecution. So once we have sale for profit, we can pretty easily say, well, OMMP doesn't allow that. So you're not unambiguously compliant with state law. It's just kind of an easy way to get there. But when we're out there doing investigations, we're not saying, for example, to drug teams or to federal agents, just bring us the ones where there's a lot of cash. So it's more of, we're looking at several different factors. We're looking at quantity, we're looking at distribution, we're looking at transfer of money, we're looking at over state lines. All of those are factors that we're considering with the objective of trying to determine whether or not somebody's compliant with OMMP as a threshold determination before we initiate any type of action. Hope that's helpful.
Thank you. Very good.
I have stayed longer than I meant to, but I think I got here a little late, but I do need to drive to Newport, so if I could have maybe do 5 more minutes?
Sure.
Okay,
Thank you. I just wanted to piggyback off of what Ben said, and my name's Cheryl Smith. I'm Executive Director for Compassion Center in the Bay Area. And so I had a question. A big issue for those of us that are advocates is that many patients don't have access. So you're talking about overproduction and it's going elsewhere, but this is a big problem. So on this clear and unambiguous, if an organization existed that only acted as a clearinghouse between patients who wanted to share their medicine without consideration, is that something the U.S. Attorney's Office would have a problem with?
I really don't want to comment on. It's difficult because you have to understand that is illegal under federal law.
Yeah, I understand.
So it just puts me in a really bad position to basically to say to any citizen, it's okay that you violate federal law. I mean, it's one thing that the Attorney General has said, as a resource issue, we're not going to prioritize these cases for enforcement. It's another thing for me as a U.S. Attorney to tell a citizen, go ahead and break the law and we won't prosecute you. So, yeah, I'm just not comfortable answering those types of questions. I will say it's hard for me to understand why people have difficult access when I have, over 100 dispensaries identified for right now.
Some people
They won't go there. Oh, they won't. The patients won't go to the dispensaries.
That's right. I think you come here extraordinarily prepared. I was amazed at how conversational you are on every subject, every ball, everybody threw it to us. Quite remarkable. I really appreciate it. And I want to ask you one last question. Can you just give us some insight on this advisory committee?
Yeah.
They're public officials, so you can tell us what they're talking about.
Well,
are they becoming more hateful toward this medical marijuana?
No, I've been really, I gotta tell you, I mean, as somebody who came in as a U.S. attorney, first of all, late in the game, if anyone remembers, my process took 2 years. But late in the game, late to the party of this administration and this discussion, and really with, a state perspective. I mean, I grew up in, I hate to think that anyone read Brian Denson's article in the Oregonian, but, as a kid who grew up in Marin County, hanging out backstage at a lot of Dead shows, and then going to U of O and being in Oregon for the last 24 years, I was really pleased with the reasonability and the tenor of those conversations. I mean, I think folks are very thoughtful. There is no discussion about, the killer weed. I mean, that is not the tenor of the discussions at all. It's really been very much, how do we manage this within our districts? How do we strike a balance? How do we come up with a reasonable way to address the excesses and be clear about, what we see as the problems, and not be, off and running on some other tangent. So I think the conversations have been very reasonable, and they've been really helpful to me anyway.
I just got a quick, you mentioned earlier in relation, how you love constitutional law, and that's the core of yours. And one of the things that I sort of, it's always happening to me is, I'm sure you're prepared for it during nullification, and how that plays a role.
I have a real problem with that.
And how,
morally, I gotta tell you, I'm happy to talk about that.
What? Well, no, I was trying, because it is tied in constitutionally, and you love the Constitution, and so I was wondering how if you really morally have a problem with it, but then loving the Constitution, where do you see that? And I don't think the Constitution in itself, I know that it's a constitutional issue, but do you have a problem with jury nullification?
Yes, I do, and here's why. And interesting, this is funny, because I recently had this discussion socially offline with some folks who were non-lawyers, friends of my sister's. And I, as somebody who was a prosecutor and was in jury trials, I mean, I think I clearly tried well over 100 jury trials as a deputy district attorney. So I have a lot of experience with this, and one thing that I know happens, first of all, I do believe it's that the democratic system works because the legislature is supposed to make the law, and the executive is supposed to enforce the law, and the judicial system is there to interpret the law. And I think it's, in my opinion, the job of the jury to apply the law to the facts, and if they don't like the law, to get involved in the democratic process and lobby their legislature to change the law and get rid of people that they don't like. That's my view of it. Now, the other thing I will tell you that I know from sitting in a lot of jury trials now, also in the federal court, is that jurors are asked to take an oath as part of voir dire, and they engage in a colloquy, oftentimes with attorneys, but sometimes with judges, and sometimes with attorneys and judges, after they've been sworn in and they promise to tell the truth during the process. And in my experience, when I've seen jurors nullify, and by the way, every time I've seen it happen, it hasn't been a jury, it's been a juror. It's been one individual that has led to an acquittal in a 11-1, or in the state system, you know, maybe actually I can't think of a 10-1. I only think of 11-1 where I've seen it happen. So it's been one person that's nullified the other juror's verdict. Every single time I've seen that happen, that juror has lied during voir dire. And so for me, I guess, I'm not a liar and I have a problem with lying. And so the constitutional thing is a different issue, but I think it would be very difficult. The only way, the ways that I've seen it happen, for example, we had a death penalty case in Coos County where a juror, I was in voir dire, I wasn't a counsel table, I was observing from the back of the courtroom. And this particular juror was asked under oath, you know, would you have a problem applying the death penalty? And she said, absolutely not. I'd follow the law, I'd apply the law to the facts, if that was what was called for. I'd answer the questions, I'd consider the evidence, I would do everything. They move on, and then the death penalty was not applied. The other jurors contacted the judge and said, they actually deliberated for a very long time, multiple days. And when they came out, I think there were 3 people on the jury who were in tears. And it was this one juror, and then they reported to the judge. They wanted somebody to do something. Of course, there's nothing that can be done. This person's not going to get the death penalty. But everybody else on the jury said this juror came in during the penalty phase and immediately announced out the gate, I'm not going to vote for death. I don't believe in it. I never did. I purposefully stayed on the jury to make sure that this person wouldn't get the death penalty. Now, because if she would have answered truthfully in voir dire, I don't believe in the death penalty, I have strong opinions, she would have been excused for cause. And so that's what I've seen. That's my experience with it. And so I feel like if you are not asked in voir dire and you stay in and you nullify, okay, that's part of a bad lawyer. I haven't seen that happen.
Well, yeah. I'm sorry.
Yeah, so that's the feeling I have about it.
Well,
I think that that's how democracy should work.
And the tie-in, I guess, is just sort of, yes, that I fully agree with that anecdotal statement in relation to murder. But in relation to the question I was asking was more specifically, in fact, to tie into a more direct, which is the one I didn't ask, to be a precursor, is do you feel the war on drugs has
do I feel the
war on drugs has succeeded? Do you feel that, like, on a personal level, you know, just on a personal level, do you feel that prohibition has been effective? The war on drugs is specifically marijuana.
I don't think that we have, holistically, I don't think the war on drugs has been effective. No, I don't think I think that's pretty uncontroversial. I mean, and I hope and I believe and I know that the Justice Department is very committed to looking at other things to do. I mean, that's why we have the Second Chance Act and reentry courts, and and there's a push, not only certainly not only federally, but here in Oregon, a very strong push. Dr. Kitzhaber, the Sentencing Commission. I mean, all the work. I sit on LIPSIG for Multnomah County. I mean, all the work that's being done in terms of taking a hard look at best practices, use of treatment. I mean, you know, I have people in my family, one person in particular who I love dearly, who you know, is a recovering drug addict and is a treatment provider, has been clean and sober for 16 years, and she was arrested and luckily had the opportunity to go into inpatient treatment instead of prison, and is you know, absolutely the most inspirational person in my life today. And so you know, and again, I don't think I'm saying anything that's overly controversial. My colleagues, I think, share these ideas. But the problem is, we find ourselves where we are. And a lot of the discussion today, I think, is more appropriately geared towards the legislature, a bunch of folks that I'm not supposed to talk to and try to influence. So I'm trying to be careful not to do that. But you know, I think that we are at a time where those conversations are happening, and this is all part of it. But for me, as Oregon's U.S. attorney, I don't want anything happening in my state that brings more crime into my state. I'm glad we're not the first to legalize, you know, because I feel like we have, I mean, to be quite honest, because I feel like we have this unique growing climate, soil. We are different than if marijuana is legalized in, you know, Connecticut, because of our ability to grow big, beautiful plants in Southern Oregon. And that is a magnet for people whose objective is not compassionate care for people with cancer and glaucoma, but whose objective is drug trafficking and all of the bad stuff that goes along with it. So it's a complicated issue. I'm not here to talk about what we should do in terms of national drug policy as much as I am what I can do as a U.S. attorney in Oregon to enhance public safety. All right, I gotta go to.
Thank you so much
Yeah.
for staying with us. And please stay in touch if you're interested in staying in touch with us.
Thank you so much.
Thank you so much.
Okay. And we're gonna take a break for lunch and return at 1 o'clock.
Cheryl, I did get your message this morning about the attendance. Yeah. Right here, Aaron, she's right here on the first floor.
Okay.
He may bring back.
Can someone check if there's a sign-up sheet over there for public comment?
There is.
There is, okay. So if anybody wants to speak at 2 o'clock for the public comment, feel free to sign up on the list there. Great. Okay, so we're going to continue the agenda item of the proposed ACMM bylaw amendments, which we moved up in the schedule a bit.
Okay.
So
When we start off, you know, I addressed all your questions. So you want me to go through why these changes were made, or how did you want to address it?
yeah, if you feel there's, see a lot of it's house cleaning.
So, yes, so under the justice, that was removed because the statute already outlines what your role is, and it's basically, we just, it's the same as your mission, so we just took that information because it was necessary. This doesn't apply any longer because the committee has already established it, so that was removed because there's no need to keep that in there any longer. In regards to the term limits being staggered.
I tell you what, how about if we go through these section by section, you can explain the basis for the need for the change,
Okay.
and then if there's any discussion, we can do
Okay.
that and
Okay.
move on, yeah.
So Article 2, as I just stated, that language wasn't necessary because the committee, the mission pretty much sums up what your role is.
Do you want to move the microphone back over in the middle?
Sorry.
So you deleted the mission of, and it
Because
still
it's,
remains.
according to statute, this is what the committee is to, and so we don't need to say that it's a mission. It's copied straight from the statute of what your role is.
Is there any reason to delete the statutory authority for the ACMM?
Right, that was removed because 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 it's not necessary to state the statutory authority when we're just saying what your role is here. Outline.
I would suggest keeping, well, just editing the language of section 1 of Article 2 to just edit it to the present tense. So I think it's still important to establish our statutory authority, but just house cleaning to make it into the present tense.
Meaning was established, is that what you mean?
Yeah, exactly.
You're talking about the part that was taken out.
Yeah, instead of deleting it, just editing that section to make it in the present tense, as Sandy suggested. It was established, subject to Senate Bill 20. Yeah. And the advisory committee shall exercise and carry out all powers, etc.
I agree.
Okay, is that a second?
I have.
Okay, any discussion on that?
I guess I would amend that to just say the advisory committee on medical marijuana is established under Oregon Medical Marijuana Program, ORS, blah, blah, blah. And you can cut out the whole history of the Senate bill and that sort of thing.
I think it's important to leave it in there.
I do too.
So the way
For
things
reference.
change so quickly,
Yep.
and then nobody will even remember why. We should have
Does it matter
access.
that there was a Senate bill that
I think
established?
so, because we can look back and see what it is.
Yep.
Things
Legislative
change
history.
very quickly and just disappear.
Personally, when I came on, before I came on, when I read this, I actually referenced back, I Googled it, referenced back to it.
Usually if you look at statutes, you can find it.
No, I know,
That's
but it
right.
helps a ton if you actually have.
Because it's already in the
Yeah,
statute.
yeah.
Okay, any other discussion about that? And I suppose we don't necessarily need to decide upon the specific language on some of these right now. We can just agree to, editing that to reflect the present tense, and there's no real controversial aspect, and we can just work on it in the interim and then come up with a new draft to propose and agree to enacting next meeting. Does that sound about right?
So moved, so what you're saying is, I second to table this until the next meeting, and between now and draft.
Well, I would say, yeah, that the motion is that we will edit this to reflect the present tense
Yeah.
in the interim, and that would be the context, I guess, for any motions that we pass regarding this document. Sandy?
Okay, I think we do need to change is to was.
Mhm.
That would be my only change.
Okay. Okay, good. All right, all in favor of that? Aye. Pass unanimously?
No.
No?
I didn't ask for names.
Oh, I'm sorry.
I'm not sure what we're voting on, the first
Oh.
motion or the second motion. Because we
We're-
didn't vote on the first one, and then you came up with the second one, so I'm.
Oh, no, I was perhaps clarifying. Okay, let's
Okay, all right.
redo that. Sandy made a motion to edit Article 2, Section 1, instead of deleting it, by bringing it into the present tense, with the friendly amendment that we will do the drafting, the exact wording on the interim. Okay, all right. I guess second that clarification.
I second that.
Okay, all in favor? Aye. Abstain. Okay, so one abstention, no nays. Any nays? Don't want to lead it, the question. Okay, so motion passes with Cheryl abstaining. Okay. And then section 2, Tawana, deleting the words mission of the, making it committee shall.
Yes, because that's what their role is. You need to say that it's a mission, because it's the role of the court, and that's how it reads in statute.
Okay. All right. I come from a nonprofit board kind of thing where the mission of our nonprofit boards are kind of our guiding principle. but I guess I have less experience with advisory committees, mission statements. In your experience, is that relevant? Do most advisory committees have mission statements, or?
Other advisory committees that I serve by the state don't have mission statements.
Does anybody feel the need of it being called a mission statement to be a guiding principle or anything? Stormy?
In 2005, when Senate Bill 1085 was passed, the reason this was put in as an advisory committee is because until a department or agency has an advisory committee, they're really not taken serious yet in state government. The advisory committee gives that program their window to the rest of the state. And without it, it just doesn't work. I sat on vocational rehab division advisory council for 6.5 years. And it was through the council that things got changes made. This program desperately needs this advisory committee. And if we need to work harder to get the information and get the response and the communication that we need, then we need to do that also. And I'm the one that didn't get the letter going on Dr. Goldberg. I guess I didn't even realize it until Todd asked me just a moment ago. It's something that is very, very important. And please, if I ever don't come through in a timely fashion, knock on my door again. Because chances are, I still want to do it. I just haven't gotten focused on it yet. But the advisory committee is so important to the program that we don't ever want to give this up in any way. And I feel very comfortable knowing what the mission statement is. It gives us direction. And so I would ask that my fellow committee members to vote on keeping that direction.
Second, you want to second that?
I do. I'd like to further discussion.
Okay, we have a motion. I'll second it, and then we can discuss it. Yeah. Okay. So go ahead.
Yeah, I believe entirely in what in the mission statement, but I'm wondering, because this has kind of been a lifelong, for this program, question that we've been asking the legislators, because we never knew what the intent was for us. And coming up during my time I was given for the talking to Gail, who we thought were going to be here, the reason for those questions was because we need to know from the state what they believe that our purpose is. That's something that's never been answered and has been argued and speculated ad nauseum, you know. And Laird would, you know, I think many of us have talked to Morissette in the early days, believed that we were supposed to have a lot more input on legislative matters, but across the board, it seems like most agencies aren't. And maybe the advisory committee, since it was the advisory to the district, was supposed to be the group that was supposed to be bringing that forward, because I think most agencies are asking for either help or cooperation, and in some cases, grants to further their, you know, direction. So it's hard for me to come up with a mission statement if we don't know what the intent of the state is, we're on a meeting. And that's why the letter to Bruce is a good idea, because that should clear up some of that. But also that we need to have that kind of clarified to us. Otherwise, we're writing a mission statement based on something that, you know, the administration may not agree with. So how can we do that? In other words, what's going to come first, the chicken or the egg? So it's kind of like I'm going to be withdrawing my part of the committee business, since Gail won't be here because she was or would have been the head, or maybe it could be brought up again at Bruce at the meeting that Bruce Goldberg's going to be there. But it might be a good idea to definitely shelve this until that time when we get clarification from above, so that we know what we're writing a mission statement about.
So we have a motion to leave section 2 of Article 2 alone, correct? Right? We need a second for it. Okay. So all in favor of leaving section 2 alone? Aye?
Are
Okay.
we talking about, which one are we talking
Oh,
about?
Article 2, section 2.
Got it, okay.
Okay, I'll see hands real quick. All in favor? Okay, anybody opposed? You opposed? Okay, motion passes. Cheryl opposed. Okay, and I see the next one is just house cleaning. The terms shall be.
Right.
All right, and so removal of members.
I have a.
Yes, no problem.
I would like to change the bylaws so that the director may not remove any member of the board at his or her pleasure. It should be that the director may recommend to the ACMM that he or she wants to remove a member of the board, but ultimately it's up to us.
Would you like to explain the basis for that change?
That's a motion.
I second that motion.
Okay, I'm sorry, that's a motion. Second
So,
to
because the
discussion.
statute clearly states that the director will appoint, and it doesn't state that the committee can remove anyone. The appointment is by the state. The appointment for this committee is by the health or director, and as a part of your role that to advise on this, you're not giving the director direction, you're advising, so he's the only one that can appoint and remove according to statute. And so that's why that was taken out.
And that's the point and remove?
I don't see remove.
Well,
I don't see the remove
Just
either.
a point.
Yeah, it's only a point.
Statute requires him to appoint. Where's that
Okay,
one? Go ahead.
so if he's the person who's authority over this committee, he'll be the one that may remove the person as well as he gonna appoint. You guys are advising him, but you take, the direction comes from him. So I can see, even when, I can see when if there is someone you can share your advice about that decision, but I don't think you can't say that you have authority to remove anyone from there. And that's why it was taken out, because the direction comes from the director.
Didn't the director always have the authority to remove members?
No.
No?
No, if you write it into the bylaws or the administrative rules, then that's the authority he or she has. You can't take away the appointment authority, because that appointment authority is given by statute. And as we'll discuss later on, you can't create an administrative rule that's contrary to the purpose of the statute. But it doesn't say anything about removal.
Right.
So at that point, and whatever administrative rule or bylaw they want to promulgate is up to their discretion. And if we're the ones that are drafting and approving the bylaws, then it becomes our discretion. And so once appointed, we want to be involved in any removal. And we want a majority of the ACMM to, pardon me for using the word approve or removal, but that's.
They can be involved with you, not, but this is reading that you're gonna make that decision, and that's why it was moved. It's not even, it's stating that the committee may remove a member. And
But I'm talking about above there, what's written in black. The director may remove any member at any time at the pleasure of the director. We don't, or at least a couple of us so far don't like that. We want that, once appointed, in order to be removed, it has to be by a majority of the ACMM.
Yeah, and I had commented that I think we need to allow 2/3 of the committee to recommend to the director removal of a member. You know, that doesn't seem right to me that the director can just arbitrarily remove anybody.
Yeah, I don't see any conflict with the statute about the committee members, or the committee removing, I'm sorry, yeah, I don't see any statutory conflict with B, so I think that's important to leave in. And also, we don't want to be bothering Dr. Goldberg about every micromanagement decision this committee makes.
That's not the motion.
Okay.
The motion is I want to change the black letter to right.
Right. But you want to retain.
Oh, absolutely.
You want to retain B. Okay. So that's what I'm arguing about. Yeah. Okay. Stormy.
My comment is on B. When I was appointed by Dr. Gomez, I was not appointed to be a decision maker on his body of committee composition. That is something that he knows so much better than any one of us sitting here could possibly know.
You hear her?
That I would not even begin to make a decision about one of you, whether you should be here or not. Dr. Goldberg has already made that decision. And so for me, he will be the one that will tell me when it is time for me to go. I sit here in this seat and bring information from the state to be able to advise Dr. Goldberg. I'm part of this committee and I'm very honored to be a part of it, but I am appointed by Dr. Goldberg, and I'm sure that I will be one day maybe perhaps removed or retired by Dr. Goldberg.
Okay. So let me clarify the motion. Your motion is to amend the A, as you said, to recommend removal by the ACMM. And that also includes retaining B instead of deleting it? Okay.
I don't know if that's two separate motions or one, but I would make both motions.
Okay, it sounds like one motion to me is appropriate. Actually, just given the comments that some of us made here, I think we probably should make it into two motions. And anybody want to second the second motion? Yeah. Okay. All right. Yes, exactly. Okay, so we're going to vote on the first motion to amend 3A, that the director may recommend to the committee must
in order to remove.
Okay.
It requires a majority of the ACMM.
Okay.
The director must submit his or her recommendation for removal to us. And ultimately, it's up to us by a majority. And if I can respond to Stormy for a moment, I think if, once you're on a committee, a government committee, if you can be removed at the will and whim or pleasure of that government agent, then your speech is going to be chilled. Maybe not your speech, maybe not my speech, but ultimately, you're going to be thinking about, well, if I go against this guy, he's just going to remove me. So I better stick with his agenda. I better do what he wants me to do and vote the way he wants me to vote, or else he's going to kick me off. And that's why that kind of discretion on the First Amendment isn't given to government officials. Once you're in, you have to be free to comment against the person who you're advising, so as to be free from any chilling of your ideas or actions of being thrown off the board because he doesn't like you or she doesn't like you. And it's not a comment on Dr. Goldberg, it's nothing personal about any of it. It's just a standard pattern of First Amendment jurisprudence that says you don't, if you're a government official, you don't have that discretion over people who are serving. That's my only reason for doing it.
All right, quick one, Jim, and then Stormy.
Yeah.
We also have a lot of other amendments to look at too.
Right, I just want to say that I really kind of think it's a lot to do with the evolution of the actual program, because in the beginning there was no ACMM, so therefore Goldberg had to appoint everybody through the process they went through. Now that there is, and we're writing our bylaws, these are the type of changes that probably, present growth to what we're doing. And so it's like even now, the board is asked for their, recommendations on who the next people are, although they're still appointed by Dr. Goldberg, they're at least being, vetted by the board itself. And then whether he takes it in heart or not, we don't know. But it seems to me like so far to this point that it always has been. So, I just think it's part of the growth. And it's, I agree with Brian's thanks.
Okay, and Stormy, last quick comment.
Even as a council, we were not appointing the people or taking them off of the council. Dr. Goldberg lives in a realm that few of us probably can even imagine. He has got so much facets to him and knows so much more. This is his advisory committee. He should have absolutely the power and right to appoint those people that can do the best job in advising him. And Brian, when you talk about it hindering whatever that person that's been appointed is doing, if that person that's been appointed is in conflict with what they are about to do, they probably shouldn't be on that advisory board or committee or council. To work extremely efficiently, because we're not coming there as individuals. We're coming there to get something done.
And sometimes disagreement is better than yes man. Or yes
Okay.
people.
I think we've had enough discussion on that one. All in favor of Brian's First Amendment, say aye.
Aye.
Aye. Any opposed? Okay, motion passes with Stormy opposed. And any discussion on Brian's Second Amendment to retain subsection B, 3B? Okay, all in favor of retaining the language in subsection 3B of Article 3? All in favor? Aye. Any opposed?
I'm going to abstain.
Abstain? Okay. Okay. Yes?
I just, you're gonna hate me. We've had an issue in the past where people who have finished one term have not reapplied for appointment. And so if we look back at the terms of offices, a member is eligible for reappointment and may serve for 2 full terms. I think we need to add a member is eligible to apply for reappointment. We'll make it very clear that you have to put in that second application. Remember how John Sajo didn't do that and didn't get appointed? I think that would, just those 2 words, you're eligible to reapply for reappointment, would clear that all up. Anybody agree with me?
Let's hold discussion on that because it's on a different section than what we're voting on.
Oh, I thought we'd already voted.
Okay.
I'm sorry.
Well, yeah, we
We're
voted.
going through
we
in
had-
order
okay.
though. all these sections.
Can we retake that vote on 3B? All in favor of
Oh, I thought we
retaining
already
3B?
did. I voted
Okay.
for it. We did.
Okay, all right, and Stormy abstains. Okay, motion passes with 1 abstention. Stormy. Okay. And are you making a motion
Yes.
then? Okay.
Under terms of office number 2, to add the words in the last sentence of the first paragraph, a member is eligible to apply for reappointment and may serve for 2 full terms. That's clear, you have to reapply.
Okay. And Alice seconded. Any discussion on that one? Okay, all in favor of adding apply for in subsection 2? Favor? Aye. Any nays or abstentions? Okay, motion passes.
I just did one little area right after that too, which I had commented on, and that's just a grammatical thing. It should say, terms of office less than 4 years, as
Okay.
opposed to fewer than 4 years. It's just a grammatical thing. You're supposed to use less than when you're talking about years.
Okay, is that a motion?
Yes.
Second.
Okay. Any discussion on replacing fewer with less than?
Yes.
Or less? Okay, all in favor?
Aye.
Any opposed? Motion passes?
Can I ask a question about terms of office? How do you know when your term is up?
Tawana will tell you.
We have,
Huh?
except we have 3 members expiring on December 31st, and they haven't been notified yet, so.
Oh, I haven't been notified, am I one of them?
I know Dr. Cohen is one of them,
Oh,
I'm one of them. And
Yeah, what's-
Stormy.
No, his term ends in 2013.
Yeah, it's me, Dr. Cohen, and Stormy that are expiring on this 31st. And we're all.
I thought it was next year.
No?
No.
We're all.
Let me
we're all-
check that.
13, 9, 14.
Let me check that.
Okay.
Well,
I got that from the last document you sent out a while back.
Time is going by so fast.
We'll fix it.
Really keep up with
Faster,
everything.
faster, Tawana, faster.
All right, so let's move forward on section 4. Tawana, do you want to explain the basis for removing and emergency? Analysis. Those changes in 4.
Okay. Because there's not an emergency meeting, we're just defining it as a special meeting. Because that's what's defined in rule, it doesn't speak as, rule, statute, is it rules? That it doesn't speak of any emergency meetings. So we decided to remove that to read as special meeting.
Okay. Does anybody have any issue with that?
Yes, yeah, can I ask just a quick question? Does it specifically exclude the ability to have special emergencies by statute? Does it exclude emergency meetings?
I guess if we feel it's an emergency, we can call a special meeting.
Well, no, the question is that, the question I have, it's a curiosity question, is special meeting in the statute and emergency meeting aren't, or either one of them in the statute?
It's not a statute being ruled.
So it's not, so either
I'm
one,
trying to see
so this is the duties, we could change this however we want, not have to go through a legislative change as well.
No, you don't have to.
Okay, I just want to make,
change.
it was just an ignorance question more than anything else, so I just want to confirm that. So then, okay, so then,
All right.
So where do we came up?
Any other stuff? Looks like house cleaning, I take it. Okay, so perhaps I could make a motion to include the changes that Tawana suggested in section 4 of Article 3.
I so move.
Okay. Any discussion?
Well, I had actually had a question, and it looks like you had a comment too, on the duties of the committee, and I don't see anywhere in here or elsewhere that the term duties comes up. So anyway, it was a change of removing health and safety and putting in duties of the committee, and I just have a question whether there's a problem with that. What are the duties of the committee?
I guess that section that it is in describes the duties.
Okay.
So it's,
even though it doesn't use the term duty. Okay.
it's in the title of this section. But, yeah.
And then I think you had wanted to include health and safety.
Oh, yes, yes.
Yeah, I just wanted to make sure you weren't dropping that.
Okay, so let me withdraw that motion and amend that motion. So the motion is to retain make the changes that Tawana suggested, with the exception of deleting health and safety.
But that doesn't make grammatical sense, so how are you gonna word it?
Well, and to repunctuate it as necessary. We also remember that the context of these decisions is that we'll figure out the exact wording on the interim, so we'll make it all grammatically correct. Is there a second on that?
I'll second it.
Okay. Any discussion? All in favor? Aye. Any nays? Abstain? Okay, motion passes. Okay. So we're in Article 4. No changes on selection of officers. No changes suggested on duties and responsibilities of chair. 3. Okay, and Article 5.
I did have one thing on section 4.2. C. And it says the chair will work closely with the administrator, OHA Office of Community Health and Health Planning. Should
That
that
needs to be
also be
changed,
Center
yes.
for Health Protection as
Yes.
well?
Okay.
Okay, so that needs to be, I'd move that we make that change as well.
Sure. Anyone second?
Would you repeat that? I missed it.
On 4.2C, that where it says Office of Community Health and Health Planning should be changed to Center for Health Protection.
Center for Health Protection?
Yes.
That's what, we're not an office anymore, we're centers, and we're under the Center of Health Protection.
It was just an oversight because it got changed further on.
Good. Okay, so we have a motion to second that. Any discussion? All in favor?
Aye.
Aye. Motion passes. House cleaning. Okay, and so the same house cleaning is done in Article 5. And then we have regularly scheduled added in there on the second paragraph. Okay. Are there any comments on that?
Me, yeah, Article 5, Administrator, the second paragraph, second line, that should be a comma in meetings rather than a semicolon.
Yeah.
Oh, okay, right.
I mean, you could change all that without voting on it, sure.
Yeah, okay.
And now we can get to the meeting thing.
Okay, so make the motion to make the changes to Article 5 as Tawana suggested and correct the punctuation in the second paragraph. All in favor?
Aye.
Motion passes. Okay, so the public records, that
It
was
was
moved
moved.
to a different section?
Yes.
Okay. Anyone have comments on Article 6? I think that Section 1 should say the committee shall meet rather than must meet.
I agree.
I second that.
Okay. And can you explain the basis between, or basis for section 2 and may apply to subcommittee meetings? Oregon public meetings law
Yeah.
applies to regular and special
Why
meetings.
subcommittees? I thought we didn't have to do that. And in what case would it apply?
And it's a may. So
Yes, when?
Yeah.
That wasn't my change, now I don't understand, I'm not sure why that is, maybe, because I didn't make that change.
Okay.
I would like to see left out.
Special meetings.
That's good with me. Okay, so so I'll make a motion to adopt the suggested changes for Article 6, Section 1, and not adopt the change suggested to the same article, Section 2.
Except for the part where it says regular and special.
Yeah, that's a point of order. I don't think you.
Oh.
You just want to,
Okay.
you just want to remove the final clause on
Okay.
number 2.
Do we want to do we want to say regular and special, or I mean that does.
You could just say meetings of the committee, you could say those.
Yeah. Okay.
What's the change with regular and special? Does it say that?
Well, it's the only kind of meetings we have anyway, so it probably doesn't make a big difference.
Okay.
Okay, so the motion restated is to adopt the suggested changes for Section 1, but not adopt the changes, the recommended changes for Section 2.
Except for shall instead of must, right?
Yes.
Discussion on that.
Yes, yeah, including the shall.
The second is.
Okay.
Discussion on that.
Discussion, yes.
I would like to recommend that it be amended to read Portland, Salem, Eugene area, one meeting outside of the Portland, Salem, Eugene area.
I disagree.
Oh, I see.
Okay. Okay, we don't have a second on that.
I'll say.
Oh, wait a minute, we're, okay.
We're in the
are we
middle of a
discussing
motion.
that
Oh, no,
Yeah.
as
we're
a-
discussing the same.
a friendly amendment?
Yeah.
You'll second that?
Sure.
Okay. Okay, so, okay, can you restate that friendly amendment again?
Yeah, I would recommend that it be changed to read Portland, Salem, Eugene area, one meeting outside of that area.
Okay.
Excuse me, Todd, I'm
Yes.
just having a hard time capturing all the motions, because you're making several at
Yes.
a time.
Okay.
You are using the mic, so it's
Okay.
hard to hear.
All right, let's take care of the original motion first, and then we can add a second motion. Okay, how about that? All right, so the first motion is to adopt the suggested changes in Section 1 of Article 6, as well as replace must with shall, and not adopt the changes suggested in Section 2. And we have a second on that. All in favor?
Aye.
Aye. Any opposed? Okay, motion passes. And we have a second for Dr. Lerberger's to include Portland, Salem, and Eugene metropolitan areas. And they have a second
6-1.
in Article 6, Section 1, yes.
Is that Portland and Eugene?
Portland, Salem, Eugene metropolitan. I know it's, yeah. Can we say the Willamette Valley? Because that's about the same territory.
About I-5 and then go to I-84.
Yeah, let's look at the other side.
Yeah.
We also have 12 minutes left to go through all these other things too. So can we make it the Willamette Valley instead of, okay. Okay, so friendly amendment. All in favor of
I'm against it, yeah.
yeah.
But I.
Well, you can vote against it if you want.
I will, but I want to have some discussion.
Discussion.
I mean, it would
Okay.
seem to me that the purpose might be better served if we have at least 2 meetings outside the Portland, Salem area. and at least one of those two outside the Willamette Valley.
Will we accept that friendly amendment? Okay. All in favor of Dr. Lehrberger's motion with the friendly amendment? Aye.
Aye.
Any opposed?
Aye.
Okay. Any abstaining? Okay, motion passes with Sandy nay. Okay. All right.
I have next one, 4.3 one.
Okay, so we're on quorum. Is that one? Okay.
One of the things that we have learned in the past, just so everybody is aware of it, in fact, when we first started with Shannon, this came to light. A quorum is 6 people, but all 6 people have to vote the same way. Yeah, we've been around the block on that one with Shannon. Twana, you weren't, it was with Pam. And this is what I found when I was on the planning commission. If you have less people, if you have less than 6 people voting out of 11, it doesn't count. You have to, I swear, we've been around the block. Twana, you weren't here. Aaron, I think you were here.
But he
This
didn't
was
attend the
Shannon
meetings
just
in the
first
past.
came on, we had a big talk about it. She disagreed with me. I had already been through it with the planning commission in Wasco County. And we'd gone to the state, and yes, if you have 11 people and only 6 people are there out of that 11, all 6 have to vote the same way in order for a motion to pass.
It has to be a majority.
I'm absolutely sure of that.
Yes.
Okay.
So to do that, we don't drop the board.
No, I just think that a quorum can be 6 people as long as they all vote the same, but only 5 of those 6 vote, that doesn't pass. And I mean, we went round and round about this, first with the planning commission and then with Shannon, so you can ask Shannon.
Possible, because otherwise you can have a minority of the.
Yeah, you have minority of the committee, that's right.
So,
Okay, so do you have a motion?
What's a board?
It says board members, that's what I
It
just
says
got
that
thrown on.
underneath.
It should be committee
It
members.
says right under, at least 6 votes are required for the committee. Oh, it said that, I'm sorry. Sorry, Cissy.
Number
Yes,
four.
yeah. Yeah, so I believe you're making a motion to amend it to be 6 committee members.
Yes, I am, thank you.
And that's what it already says. Oh, board members up above, I see. Okay, thank you.
Okay, and did you have any further motion
No,
on that?
that's it.
Okay.
I had a friendly just question about that. Is that, so, because it's to have a majority, right? There's 9, you know, I know you want to pass, but if we drop that to 5, you can still have a dissension if there's 6 people.
I think you have to have 6 for a quorum, and all 6 have
So
to.
you have to have 6 for quorum no matter what, so that's not arbitrary, that's
No.
All right, I'll second Cheryl's motion and call for a vote. All in favor of replacing board with committee in
Aye.
section 4? Okay. Any opposed? Okay, passes. Okay. And to do the same for the next section for committee action.
Make a motion to make the change.
Okay, you just did, and I'll
Second.
second. All in favor?
Aye.
Great. Special meetings.
That was changed so that we can have clarity of how the process will work. Then there is a need for you all to have a special meeting. So, because there wasn't anything clear stated to reduce that confusion. So we don't run into it.
Here's my take on that. These bylaws were drafted before you were here, correct? I believe Pam was the manager, yeah.
I think.
And we were in DHS then. So basically,
I believe the original bylaws were drafted by Shannon.
Okay, yeah. So because the statute says that the meetings shall be held at a time and place chosen by the director. That's pretty much what the statute says, which I guess you're referring to as the need for this.
Yes.
It was understood by me at the beginning that because the agency had had written these bylaws for us to pass, that was intended to be the authority the authority that satisfies that statute. By passing down these bylaws to us, that's saying that the director is giving us the authority to choose the time and place in our meetings. And that's been my understanding so far. I don't think it was intended that we would have to bug Dr. Goldberg every time we wanted to have a quarterly meeting or schedule one. I think it would make our meetings pretty cumbersome if we had to check with him every time.
This is only for special meetings, this is in your special meeting.
Oh, right, special meetings.
Not all the quarterly meetings.
But,
Because the quarterly meetings is already outlined that you have quorum, and they must be held in the areas. So that's already written there. And the special meetings wasn't outlined in the word how the process would work. So in this last incident, we, Gail said there needs be some clarification and process of how a special meeting would be held, because this last one, it wasn't clear that it was a special meeting. And I know it was in the meeting minutes before, so we had put set motion for that. However, Gail wasn't aware of it. Goldberg wasn't aware of it. The public health director, and I wasn't even aware. I didn't realize that was what was going on, even though I was present. I didn't know when Annette started scheduling. She just said that you needed a meeting, so she thought it was for a subcommittee meeting. And because with different administrators, everybody practiced differently. And Grant and Barry will just say schedule anything that they need, because they can use, because these conference rooms are used by other outside agencies, that they can be used for other people. The public sector, private sector can use our conference room for things. They can contact the building manager. So she felt that, because we always practice that, we'll just set the meeting up for a subcommittee if they need a meeting room. And that's what she thought she was doing, setting up a meeting for one of the subcommittees. She didn't have it clear. That's how she presented to me, that she didn't understand what was going on.
Okay. I don't want to rehash that again, but
I understand. So we wanted something to say this is how it would happen, so there's no confusion. And I was given direction by Gail to make sure that it is clear and so forth.
Well, I have a hard time seeing how there was confusion, because it was very clear in the meeting when we chose it. We did everything according to the bylaws and administrative rules and statutes. And the only time Gail had ever responded to one of my emails for ACMM business, it was to tell me that she was excited to attend the special meeting with the Attorney General.
Yeah.
But she didn't show up.
Yep.
And your staff didn't show up, and that was at no fault or irresponsibility of this committee. But anyway, I think it's a poor example for justifying this. I think the current language is quite clear, and with Gail leaving, I think perhaps if the agency has an interest in changing this process, we can talk about it with the new administrator.
I would make a motion to that effect, Tom. I think you're right about that. I mean, the changes here take out any, there could, I mean, I don't know what the situation would be, you know, just hypothetically, but there, what if the need for a special meeting arises between regular meetings? This cuts out any of that, and so we could be left, and let's say tomorrow something comes up that we really, 6 of us believe we need a special meeting. We have no way of making that happen until 3 months from now, when the next quarterly meeting occurs, because it's taken away our ability to email to Todd and request this and then have him get permission. And so, I don't know, it seems to me it's pretty clear as well on how that was requested.
Okay, so I move to not implement the suggested change for Article 6, Section, well, the special meeting section. It's being renumbered, so I guess what will be Section 5, okay? Any further discussion? Okay, all in favor? Aye. Any?
Just, where's the old wording about how we have a special meeting? Is it been not deleted?
It's not in this draft.
So would we put back in there?
It would just not be changed.
Okay.
Okay. And I believe we just voted all in favor. Anybody?
Aye.
Anybody nay? Okay, motion passes. Staffing. OHA will not provide staff support for subcommittee meetings.
Clarify that we will not do that. It's just clarifying that, has it been addressed that we will only support the regular scheduled, regular meetings and special meetings. And we will not support the subcommittee meetings.
Rather than their work.
We never have, but I think we have scheduled rooms and stuff for some of those subcommittees. And that's where that confusion kind of overlapped there.
Yeah.
That's where Annette thought it was a subcommittee meeting she was scheduling for. So we thought we would make that clear here.
Can I make a suggestion that
Sure.
instead of OHA will not provide, just have OHA may provide, because there may be instances where we would need it inside of subcommittee setting. And so it leaves the option available as opposed to striking it entirely in the future.
Okay.
So I guess I propose for the first sentence, again, the second sentence, OHA will not provide staff support for subcommittee meetings, strike will not, and insert may.
Okay. Do we have a second on that? Okay. Will, or OHA may provide support for subcommittees. Okay, any further discussion? Okay, all in favor?
Aye.
Any opposed? Abstained? Okay, motion passes. Any comments before we get to Article 10? Okay. So Article 10 is travel.
I had some language, you'll see it on the back of the page there on subcommittee meetings, that I thought would, if it were rewritten, it would make more sense.
Yeah, that's what I'm wondering.
Are we in Article 10?
Yeah, yeah. So are you making a motion to replace this with your suggested wording?
And keep in mind that TAM and funding, we have to stay in compliance with the accounting manual as well.
Well, my intent there was to retain the sense, but just make it, just put different language to make it more sensible. So I wasn't intending to make any actual changes.
What are you talking about, Cheryl?
Under Article 10, subcommittee meetings, if you look on the very back, it's got my comments that I made when I went through this. And so it's some of the same language, but it's just worded a little differently. And you'll see the 4 dots after A, that means that take the rest of the sentence the way it was. But it doesn't change the content, it just changes the clarity.
Okay.
Could I make a request where it says subject to availability? What is that availability in reference to? Just a decision that it's available or not, or actual funds in the account? You go to Article 10.
They'll take about 3.4 million.
Well, no, I know. The question is, that may not be available funds because it's pre-committed to the other. You see what I'm saying? You know, so that was the question. The availability of the 3.4 million.
Right.
I was thinking, like, will get paid.
That's what it means.
So are we on Cheryl's motion, is that what?
Yeah.
We have to state that.
Do we have a second for
We have
Cheryl's
to
motion?
state that.
Yeah.
I second.
Okay.
Are we back here?
Okay, so we have a second on Cheryl's motion to revise the proposed language with, and this is more of a theoretical thing that we'll figure out later.
Yeah, I mean, I can give, I
Okay.
can give you the wording. Yeah, I mean, it's in writing here.
And then we'll work on improving the wording
Yeah.
later in the. Okay,
Absolutely.
all right, so any further discussion on? All right, all in favor?
Aye.
Aye. Any opposed? Okay. Motion passes. Okay.
You guys are out of
yes.
time.
We still have a couple of things we have.
You have a lot of stuff on here.
No, we're almost there.
Let's talk about the rest of the agenda.
The rest of your agenda.
Right. Yeah, you're right. I could submit.
We'll have to table all of that.
You can scratch mine.
Okay. All right. Is there anything else on Article 11?
About Article 10?
Oh, Article 10.
Under subcommittee, I think it'll only really work if we're required to notify the administrator of the Center for Fire Health Protection at least 72 hours in advance, and not get permission from the director. Just be required to notify the director.
Okay. Okay.
Second that.
Second over here. Any comment or discussion?
I agree with that.
Okay. All in favor?
Aye.
I oppose.
And one opposed. So motion passes with Stormy opposed. Okay. Any comments on Article 11? Okay. Is there a reason for deleting the revision history?
Stay it's not necessary to be there. That's what I was doing.
Does anyone find value to having a revision history down
I
there?
like what you
Yes.
got, I like
It gives us a trail for research.
Okay. Okay, so I move that we adopt the suggested changes for Article 12 with the exception of retaining the revision history. Second, any discussion? All in favor?
Aye.
Aye. Any opposed? Motion passes. Okay. Let's move quickly to outreach chair election. Does anybody have a nominee?
I have a statement first.
Okay.
Okay, when we originally started the outreach committee, it was to reach out to people and educate them. And as a result of that, we spent a bunch of time working with Juana on a PowerPoint presentation. She again, Art Wiskowski and I and Christine worked on getting that whole PowerPoint done and on CDs that we could give to anybody to explain about the OMMA. And what we did then was we had that PowerPoint presentation. We could reach out to people and educate anybody using that PowerPoint presentation, which was approved by the OMMP as we developed it. So it's already there to go. Then we also did things like finding out from the airports what their policies were. Again, that's outreach to everybody, educational. Then we had a change in chair. I was originally the chair and Christine took over. And then we started looking into the issues of violation of the, misuse of the lead system. And although I don't not appreciate that work that was done, I definitely don't think it's outreach. And so if we're gonna elect an outreach chairman, also the change in what the outreach committee was decided on by the whole ACMM, Christine kind of changed it on her own without any discussion with the ACMM about this is our new goal with the outreach committee. And I'm not saying that I don't think the work in regard to the problem was regard to the process was a problem, but I definitely think we need to come back to the outreach committee being exactly that, outreach and education. And I think that we'll get a lot further with that. If we want to do other kinds of things, like I think we need to keep our finger on the part about the abuse of the lead system, but I personally feel that we need to get the outreach back to what it was originally designed to do and focus on outreach. And we could do that, everybody could do that. Everybody has access to these CDs if we want them. You could take them to your hospice people or anybody in your own area, and everybody has access to that already approved by the OMMP. So I just wanted to say that before we went ahead on what we're going to do with outreach.
As a clinic director, I have never been able to get a copy of that PowerPoint presentation. I have asked, I've been told, oh yeah, you can get it.
What did you ask?
I asked Christine. I thought I had asked you, but I've never been able to get my hands on that. So I think there still is work for the outreach committee to do to get that out to people. Because it was treated like it was proprietary and,
No.
oh, you can't do it, you know.
Oh, no, anybody was supposed to be able to.
Well, anybody couldn't.
Okay, I would say I will get a hold of Art
Okay.
and make sure that we have copies. We should have copies at the OMMP.
It would make my life easier.
And I'm sure I have a copy on my own computer. computer, so.
And I have to second that too, and I'm an outreach committee member. I've asked for those copies too from Christina. and I don't get them.
And we should all be using the same info to educate people.
And that's what we
can't.
worked
I
so
end up
hard on.
regurgitating the words over.
Luana had actually given a presentation. We gave a presentation to the Governor's Council on Alcohol and Drugs. We took that and combined it with the other stuff. And I think it's a really good
I do a lot of public
product.
speaking, and it would be ideal.
Okay, so I pledge to track that down.
Okay, thank you.
Good. If we can get copies of them, I'll put them somewhere on the web and let folks.
Yeah.
Because I think that was one of the things, you weren't able to post
Perfect.
them then
Perfect.
anywhere on the OMMP site, so I'll be happy to provide a site, web space.
So does anybody have a nomination for chair for the outreach committee? Well, I guess we could table that. I think it's an important
Well,
committee.
the thing is, I'm gonna do this.
Yes.
They just resigned last
Yeah.
night.
But if that's the job, if that's what it's gonna be, I would be willing to be back, and that's my whole thing, education. And I will definitely get on this right away and try to get a copy to everybody. And they're really cheap for producing, if we could get it up on a website.
Yeah, definitely.
Or 2 or 3.
Yeah, I was
Yeah,
thinking, why don't we
absolutely. I
have
like
it
that.
on
Yeah,
our
that's a good
website?
idea.
So
Good.
I would be willing to do it, or at least work on the committee.
Good.
And then it's, because it's liable to get filed away, if it ends up with, only.
It's a really
I
good.
actually don't like that.
Does
So
anybody
I'd
have
like
a
to
motion?
nominate Sandy for
Draft it.
Sandy, I pledge to work with you on that because I have some ideas about it, but I feel too new to just jump in and
Yeah,
share.
and you can't
So
do
let's-
anything until it's been approved.
Yeah.
This has already been approved, so, okay.
Okay, we have a second. All in favor? Aye.
Aye.
Any opposed? None? Alex. Okay, any opposed? Motion passes. Super.
What is it that has to be approved?
Yeah, I
I
think
got it, yeah.
the main thing is.
She said that Cheryl can't help until it's approved. I wasn't sure what you meant.
What?
When you said Cheryl can't help until it's approved.
The project.
Oh,
Project.
we can't change the PowerPoint presentation.
Oh,
No, I don't even want to change that. I have
That's what
another.
I was talking
Because it's
about.
approved.
I'm-
Because it's already been
No,
through
I
all
got
of
you.
that. That's
Yeah.
great. But it's really good.
Okay, so the OMMP is part of the transformational healthcare system. That's going to be tabled until we can talk with Dr. Goldberg. The addition of new conditions process, I'm going to include that with my report. That'll take 5 minutes. And then we'll be.
Comment on that?
And then, what's that?
Can I comment on that first?
What?
The new conditions?
Sure. Actually, well, let me do my report. Yeah, well, it's important enough to go for it.
I think that because by statute, we are required to give advice on the promulgation of new administrative rules, and we've run out of time. So we need to table this to the next meeting, and the program, by statute, was, because we scheduled it and their bylaws agenda took up the entire time, they're gonna have to wait till the next meeting before they complete the promulgation of these new rules. Because they have not gotten our advice on this promulgation of the rule.
Okay. Well, my report includes some advice we could give them.
I don't want to give them advice, because I want to table it so we can give a full advice.
So we have the time it needs.
The reason I wanted you to not do that.
Okay. All right.
I make that motion.
Is that a motion?
I'll second that.
Okay. All right. Any further discussion on that?
To the next ACMM meeting.
Talking about before these rules can be approved, I want to be clear that that process is sort of beyond what we can decide. So,
I understand.
as I understood it, the comment period ended, but I don't know that can be, I'm just letting you know, these are different set of rules, the rulemaking. And we sort of get instructions from the rules coordinator telling us you need to have this by this date, this by this date. So I just want to be clear about that.
It ended
And I
on
just
the
want to
30th.
put them on notice that we're required to advise you, not you, but the program, and that we haven't had the opportunity to do that. The statute requires us to advise you, not you, but
I just don't want this to be seen as a motion we ignore. We might not have any option.
a motion made
That we ignore. We might not have any option. I don't know that we.
Well, in hindsight,
Understood.
they will have been, they will have not received the advice they're required to receive from us. And if they choose to promulgate the rule under those circumstances, they have to live with it.
I just
Okay.
wanted to.
All right, so all in favor?
Aye.
Any opposed?
I think I stand up there and we should get this done and get it in there. Because once that door shuts, we can't.
It's already shut.
It's already
Can you
shut.
say
It was
shut?
shut
It's up
before.
the 30th.
It was
I
already
say we
shut.
didn't
have
make
it yet.
any discussions on it now.
No, it's over. They already had their public
According to the
hearings.
rules of ordinary.
I sent mine in.
I sent mine in.
In that case, I would,
I testified.
Favorite?
Did you write?
Okay, all right, motion passes unanimously. Okay, I'm gonna make this very quick and then we're gonna open up to public comment. I have a first report from the ACMM chair. Basically, I'm reporting on the rules process. I feel it, that the current draft that was the subject of the recent hearings still falls considerably short of establishing protections against bias, prejudice, and conflict of interest, as well as some of the other goals established, and you can read my written comment to that. So I strongly urge that the OHA make these amendments, or particularly establishing the explicit protections against bias, etc., and get it right, and listen to the people who testified as well as the advice of the ACMM, so that we don't have to press you to amend these rules again in the near future. But more importantly, I think I mentioned a little of this earlier, that I observed over the history of public hearings related to the OMMP, there's been a significant dwindling of number of people testifying. I recall back in the early days, particularly around the Levesque rule, we had rooms packed. I remember someone getting injuring his knee because there was standing room only in a public hearing room. And there were just a lot of, I think there are still probably even a greater number of people who are interested in the development of our administrative rules and administration of this program. However, in seeing the dwindling numbers, this past rule hearing got me very distressed, because there were 3 cities that Aaron visited. Actually, Aaron visited 2, and then I showed up at Portland, and I was surprised to be the only person giving oral testimony in Portland. There were 2 in Medford, thank you, Lori, and Laird, and 1 in Bend. That was extremely distressing, so I asked around a little bit, and I found out that people largely lost complete faith that the OMMP or the OHA will listen to the needs and concerns of the stakeholders. And the amount of testimony that we did receive, I was still disappointed with the amount of testimony we received for the fee increase hearings, but the testimony was overwhelmingly that this would affect people's lives in a very bad way. And none of the testimony, or even any of the recommendations of the Rules Advisory Committee or the ACMM was considered the least bit in that rulemaking process. And I think that was the hearings, the process that really got people to lose complete trust. And we're seeing ACMM members who are questioning our need to be here. And I just really want to send a clear message to Dr. Goldberg that the program really needs to embrace the input from the advisory groups, as well as the individual patients who are greatly affected by this program. Otherwise, this program is really going downhill fast if that doesn't change. And after my report, I'll be happy to.
I think that's not a report, that's an analysis, that's your interpretation of.
Yes, you're right.
Okay, I would appreciate if you gave a report objectively without your interpretation.
Okay, thank you. On to my Horticulture Research and Safety Committee report. I continued working with the Portland General Electric Representative Brendan McCarthy. We incorporated the changes that were suggested by the ACMM at the last meeting. However, I reminded him that the history of the agency adopting advice and recommendations from the ACMM as pretty much not. And I cited the the rejection of our cautionary statement that we co-drafted with the Oregon Department of Agriculture. And we both agreed that it would be best if he goes directly to the program to see if you guys can work with him to accommodate the distribution of this electrical utility cautionary statement, which I feel is very important for the safety of utility workers and the public. And so probably us encouraging you to do that anymore probably would be unfruitful. But I hope he does contact you. But anyway, PGE is going to go ahead and do printing and distribution of that statement to their utility customers. And then there's still a lot of other utility companies that probably also need to get the word out to their customers for safety as well. So that's the end of my report. And we have 4 people signed up for public comment. And does anybody object to going over 5 minutes if we need to? Okay. All right. Thank you for your patience, public. We really appreciate your hearing from you. So the first person on the list is Lori Duckworth.
Lori Duckworth, I'm the director at Southern Oregon Normal, and I'm just here to just ask that I represent a large number of patients. I don't represent any growers, and in light of the fact that over the last 2 grow seasons we've been left with approximately 800 patients without their medicine because of the state law enforcement and the federal law enforcement raids. And those patients, through no fault of their own, but because of the bad behavior of the growers, their medicine has been confiscated, so it's left not just Southern Oregon patients, but patients throughout the whole state, because those growers service the whole state, as many of you know, because especially those of you that run compassion centers and service those patients have heard, because they came to you and they need medicine, they have no medicine. I'm just imploring you, the state of Oregon, the program, we need these fee decreases. The fee increases, $7.2 million between October of last year and June 1st, that's outrageous. Those fee increases off of the backs of sick patients, that's not acceptable. It's just not. And then for them to lose their medicine, and then for the committee to be ignored, the door to be slammed in their faces repeatedly. This committee doesn't mean crap. And that's how the patients see it. That's why you don't see these rooms full anymore. That's why you see these committees up here going, why do we make these 6-hour drives, 3-hour drives, 5-hour drives? What are we all doing here, wasting our time? Why do we go legislate in Salem? Why are we working so hard? Some of us for 5 years, running centers 5 days a week, 10 to 6, for no wages. Helping patients just have medicine so they don't suffer. Helping them to stay legal, good law-abiding citizens. So that their growers who have bad behavior that they thought they could trust, help them to lose their medicine. It's just not right. So please, please understand that the patients are suffering because this committee is toothless. That's what I'm here to say. Please understand the bottom line is, through no fault of their own, patients are still suffering, and they're still being good citizens and paying their renewal fees every year. They need these fee decreases. Please understand that patients are what the program is all about. And if the growers have bad behaviors, prosecute them. Send them to prison. But remember, the patients are going without medicine. And this committee is the dream team. They are. Thank you.
Thank you, Lori. Santa with Jerry Wade on deck.
Wow, what else can I say? Except Merry Christmas to you all. We have a little bit of peace and love for days, you know, for the patients too. And we do need some like supply system that's supportive for patients. We start working on that, we gotta make. Yeah, I've got some gifts here for all of you. Nice or not easy either way. If I can get two up here, I can.
Great, thank you.
Or if I can get a. Give it
I'll be the Santa's little helper. Can I do that?
Will you do my-
Yeah, I can be Santa's little helper.
Looks like you got a good elf suite too.
But no,
And since we're toothless, this cannot be construed as a bribe.
Everyone, okay, got it.
You do? I hope my Santa can I miss being able to give you guys a big basket of stuff every year. You can always send cards now. Oh, no, thank you, Santa.
That's really good. Thanks.
And we get the benefit of having Santa 4 times a year.
Oh, Brian did too.
From Santa.
It's sort of embarrassing. I spilled my car and they keep saying.
And then we need one more.
Thank you so much.
Thank you.
One more.
So,
Do you have anything to add, Santa?
I don't think so. You might take a storm.
Okay, thank you so much for the holiday cheer.
You were right on.
We're gonna invite Jerry Wade up with PK on deck.
Yes, I thank you, Jerry Wade from the Stormy Ray Foundation, and I want to report on something that I'm sure most of the committee members are not aware of. And this last trip, I know many of you have actually probably traveled with Stormy know that she requires an aide to travel with her. On this trip, after she had already traveled, she was informed on Monday that the accounting office has changed their policy and will no longer pay per diem for her an assistant to travel with her, which will pretty much deny her access to these meetings. Because without that assistant to be able to travel with her, she will have to foot the bill for her attendance food, and it's just not within her budget to do so. And it really is, I think, a violation of ADA. They're denying access of disabled people. And it's not just Stormy. If the state becomes, this is becoming a policy of the state that they will no longer pay for an assistant to travel with a disabled person to these committee meetings, And this is, I think, will affect the entire state, and I think this needs to be stood up and fought against.
So who made that decision?
I don't know, the department just did, and they did it after she had traveled this time, telling her that they didn't give her her travel pay. So she's having to try to scrounge money to even get home right now, because she doesn't have any money for this trip. She was told it would be waiting here when she got here this week, and then when she gets here, she's told that she's gonna have to refile because they changed their policy and they will no longer pay per diem for an assistant. So I think you guys need to cover and look at this because it's wrong, and it is a violation of ADA.
Terrible.
Thank you.
That's bullshit.
Yeah, thank you for bringing that. I had no
Do
idea.
you know anything about that, Aaron? Sorry to put you on the hot
I'm
spot.
learning I'm learning of these policies at the same time as you.
Well, just so you know, I'm not in anywhere near the situation Stormy is in, but I can't drive myself anywhere beyond an hour and a half. Somebody else has to take the time, so. We've always paid for it ourselves, but.
Yeah, I didn't figure the committee knew about this.
Jerry, do you know, I mean, can't you, it seems to me there'd be an administrative procedure that you could apply for a fair hearing on this. I mean, I'd be willing to work with you if you need some,
Excuse me, Ken. I don't know that we necessarily at all. This is EMS. I will meet with the patient advocacy at the governor's office before I leave here.
Okay.
And it's very important, as Sandy has indicated, and thank you, Jerry. Just huge.
Yeah, I'm not sure either, but it may be becoming a new policy for some of the agencies to not even pay per diems for their actual group meetings to get together. I just put in an application and a recommendation to get on the pain management committee, and they wanted to make sure that I knew that you now got no expenses at all, even if you're on the direct committee itself. So, you know, that's 6 meetings a year. And, you know, come if you can. It really kind of secludes you if you're not from Salem. It's not fair.
And I think it's something we're starting to see in the disabled communities. Really impressed with you guys.
If there's anything
Well, do you need
from
money?
us.
Jerry said you need money to get home. Do you need money to get home? Yes?
I give you some gift.
Okay. So I'm good. Sure. Come on.
All right, thanks, Jerry. Okay, and we have PK, and then we're all done.
Well, I'm from Mercy, down in Salem. I've been filming this on Channel 23 for a few years, letting the public see what happens. And I'm sorry that the bosses don't listen to our recommendations on client height, and other diseases that should be on the list. I'm a patient grower, and I have extreme pain. Thank you for letting me talk.
Thank you so much, PK, and for bringing us on the airwaves, too.
Yeah.
It's very important. Okay.
And Perry's putting it on the internet as well
I
at
love
the
it.
same time.
Yay.
We'll see what kind of quality shows out there before we get back.
Okay. All right. Well, with no further business, meeting is adjourned.
You want to say anything before I turn it off, Glenn?
Yes, good night.
Good night. God bless you all, every single one of you.